No.
Okay. Okay. Thank you, Miguel. Here, take your phone. Thank you. Okay, sorry for that delay in our presentation. We are live on the, or soon will be live on the YouTube, and our assistant who always does our YouTube for us actually took a vacation. Imagine that. So it was a little far for me to go get her to do this. So as you saw, we had Miguel this morning, our head of IT, helping us out on that. Okay, so I didn't hear any other, anybody else that wanted to start with anything procedural. So as soon as we get the we're live.
Got a message on my screen.
Message.
We're live.
Then we can go ahead and begin, Mr. Lee. So good morning to everyone, and we'll just wait.
I think hearing examiner
think you
Hurst,
all
I also have received a notification
See that, but it actually has to, the link actually has to be posted
on the website.
On the website in order for people to get it. It's interesting though, we sent like 3 emails on this last week. You know, it's like, we need to have this for Monday morning. We need to have this for Monday morning. So.
Examiner Hurst.
Good. Can somebody have their witness check? I've been told it's been posted.
My office is up, Judge, on YouTube.
I'm looking at the commission's website now, and you can see the link to it, but if you click on it, nothing happens.
Yeah, it's live. You can find it on YouTube, but the link on the website doesn't work. I searched YouTube for the case number, and that's how I got it, but
Can't hear you, Mr. Stewart.
Madam Examiner, can you hear me?
I can hear you, Ms. Hardy. Can you hear me?
Yes, I can. Mr. Stewart was having, he can hear you, but it seems others can't hear him. So he was leaving the meeting and trying to come back in. We did have a brief procedural issue that he was trying to address, but couldn't be heard.
Okay, have people had their witnesses try to go onto the YouTube feed? Somebody talk.
Yeah, so-
Angelica, can you hear me?
Yes, yes. So Commissioner Hurst.
It's just me then.
I figure I should test my audio as well. Can everyone hear me?
Yes.
Yes.
Okay, great.
Hold on, it's me.
I just confirmed with Mr. Pollock that he was able to access the YouTube screen.
Okay, let's try again.
Can you hear me, Judge?
Already say something.
I do hear you,
Angelica?
Mr. I did hear Mr. Lee, but did you hear
Uh-uh.
Mr. Lee, Commissioner Hurt? I'm sorry, Examiner Hurst.
All right, let's try now. Can you hear me now?
Yes, Judge. Can you
Yes.
hear me?
All right. Helps to have two pair of headphones. Okay. Did people try their witnesses and are they getting the live signal on YouTube? Hi, Commissioner.
Hearing Examiner Hurst, I think at this point, the witnesses, oh, my camera's not on. The witnesses can access the YouTube link through YouTube. It does not look like the link through the commission's website is currently live.
Commissioner, Hearing Examiner Hurst, are you on mute? You're on mute.
Sorry, I was talking to the commissioner. What I seem to remember from what Anna explained to me last week is that there are two different ways to go in on the link on the commission's page. And it depends on the browser that somebody has and is using. I don't I will let IT know that there's okay. Just told IT that. And I think we're about ready to go. Again, apologize for the delay. Mr. Stewart, you keep going in and out.
Madam Examiner, Mr. Stewart was having problems with his audio and was trying to reconnect.
Okay. He and I were having audio problems. I promise I paid my bill. Anyway, it looks like it's been reported to me that people are able to access us through YouTube, not necessarily from the commission's link. I have reported that to IT, and I believe for our purposes, we can go ahead and begin our hearing. So let's get rid of this last bit of technology, just in case. Good morning. I apologize for the delay. My name is Elizabeth Hurst. I am the designated hearing examiner in our case before the New Mexico Public Regulation Commission, case number 2200155, in the matter of Southwestern Public Service Company's advice notice number 303. Along with me today is my co-hearing examiner, Angelica Anaya Allen, who has also been designated as hearing examiner in this case. Along with us is Commissioner James Ellison, who will be asking questions of the parties this morning. Additionally, along with us is our court reporter, Mr. Lee. If anyone needs anything to do with the transcript for this case, Mr. Lee, you'll need to contact Mr. Lee. There will be an expedited transcript in this case. Today is the date, time, and place for that was set for this hearing on stipulation. As the parties know, we've already gone through hearings in January. A recommended decision was issued in February. Exceptions were taken, and the parties requested time to negotiate a stipulation, which was filed in this case, and that's what we're here today. Parties should be reminded that this is live on YouTube, therefore, anything you say or do is being broadcasted. You may let your witnesses know if they're not being examined or cross-examined in this case, that they can watch this proceeding on YouTube. Finally, I'd like the record to reflect, Mr. Lee, that a link was posted on the commission website regarding the availability for persons to give public comment in this case. No one contacted either Ms. Kippenbrock or myself, either verbally or via email or in writing, to request that opportunity. So with that, I believe we should go ahead and put our appearances on the record, and we'll begin with you, Ms. Hardy.
Thank you, Madam Examiner. Dana Hardy with Hinkle Shaner on behalf of SPS. And with me is Jeffrey Stewart of Evershed Sutherland, who will be taking the lead on this matter and for whom we have filed a pro hoc vice motion. And I'm not sure if Mr. Stewart's audio is working at this point or not.
Good morning. Can you hear me now?
Yes, Mr. Stewart.
Fantastic.
Good morning. And let's go ahead then, and we'll next go to New Mexico Large Carrier Group. And I believe that Mr. Stoffel or Mr. Rushoff?
Mr. Stoffel today. Good morning, hearing examiners. Dick Stoffel with the law firm of Holland and Hart, appearing on behalf of the New Mexico Large Customer Group. I'll also enter my appearance for my colleague, Austin Rushoff.
Very well. Thank you so much. And for federal executive agencies, Mr. Jernigan?
Yes, this is Thomas Jernigan with the Air Force on behalf of the federal executive agencies.
And am I correct, Mr. Jernigan? I don't need to address you, or do you have rank? You're not in military uniform.
No, ma'am, in this status, I'm just a civilian today. Thank you.
Very well. Thank you. And for LES, Ms. Drake?
Hi, good morning. This is Joan Drake with Modrell Sperling on behalf of Louisiana Energy Services, also known as LES. And I'm a civilian too.
Very well. I haven't seen you in military uniform, so very well, Ms. Drake. And for Occidental, please.
Good morning, Your Honor. Michael McMillan for OPL.
Good morning. And Mr. Marks?
Good morning, Ms. Hurst. Jason Marks appearing this morning for Vote Solar and Renewable Energy Industries Association of New Mexico, commonly known as REIA or RIA.
Very well, sir. Good morning. And then Mr. Bagatko?
Good morning. John Bagatko for the New Mexico Public Regulation Utility Division staff. Thank you.
Thank you, sir. I'd also like the record to reflect that Ms. Lynch, who represents CCAE, requested via email to be excused from the hearing. And I believe hearing examiner Allen granted that request, subject to the understanding that anything that Ms. Lynch is waving cross on anything that might have come up, or giving input into any rulings that might be made by her being excused from the hearing. And then, as Ms. Hardy pointed out, SPS did file a pro hoc vice for Mr. Stewart, and that is granted, and you do have the permission and the ability under the direction of Ms. Hardy, Mr. Stewart, to participate in this hearing. And if we have nothing further, we will go ahead and begin the evidentiary portion of our case. And as I indicated to the parties at the pre-hearing on Friday, we're going to begin with the commissioner's questions for the witness. So Ms. Hardy, Mr. Stewart, you have a witness.
Yes, we do. SPS calls Mr. Westberger to the stand.
Good morning.
And there you are, Mr. Berger. Good morning. You're already admitted. Excellent. Mr. Lee, if you would swear in the witness, please.
Sir, would you raise your right hand? You solemnly swear the testimony you're about to give in the matter and opinion should be the truth, the whole truth, nothing but the truth.
I do.
Thank you, sir.
Thank you, Mr. Lee. Please go ahead.
One preliminary item. We have a few corrections to Mr. Berger's testimony that we identified over the weekend. We can certainly make those now live, but if there's a preferred method for submitting, a revised or corrected copy of his testimony, we can certainly upload that to Dropbox as well.
Well, and that was to be done prior to the pre-hearing on Friday. So why wasn't that done, Mr. Stewart?
We did not identify those corrections until yesterday.
All right, go ahead.
Mr. Berger, could you please state your full name for the record?
Wesley L. Berger,
And by whom are you employed?
Southwestern Public Service Company,
And on whose behalf are you testifying today?
Southwestern Public Service Company.
Before you, you should have a copy of what is marked as SPS Stipulation Exhibit 1, the uncontested comprehensive stipulation. Do you have that?
Yes,
And is that a true and accurate copy of the final uncontested comprehensive stipulation?
yes,
And do you also have a document marked as SPS Stipulation Exhibit 2, which is a reconciliation statement filed on April 10th in this case?
yes, I do.
And is that a true and accurate copy of the reconciliation statement?
Yes,
And you should also have in front of you what is marked as SPS Stipulation Exhibit 3, which is a copy of your pre-filed testimony and its attachments. Do you have that?
yes,
Was SPS Exhibit 3 prepared by you or under your direct direction and control?
yes.
And do you have any corrections to the testimony at this time?
I do, and I apologize that I didn't find this till last night, hearing examiner. On page 17, I need to make a couple corrections.
Could you identify the first correction for me?
Yes, the list of the charges in my answer from lines 3 to 9, those charges are the wrong charges for option 2. So I'm needing to correct 4 of these charges. So on line 5, it currently says standby reservation charge. That needs to say standby reservation charge. Then it says standby generation charge. That needs to say backup demand charge. On line 6, it says backup energy charge. That needs to say maintenance demand charge. And the last correction also on line 6, it's currently says maintenance energy charge. That needs to say standby services energy charge.
What was the maintenance change?
Maintenance, strike that and put in standby services.
The correction before that?
Strike backup energy and put in maintenance demand.
And the reason for the change?
This is the wrong list of charges that are in this Q&A. These are the list of charges for option 1. and I intended this list to be the list for option 2 customers, so I needed to fix the list.
All right, sir, go ahead.
Mr. Berger, with those changes you just described, is your testimony true and accurate to the best of your knowledge?
Yes,
And with those changes that we just discussed, if I were to ask you the same questions today, would your answers remain the same?
yes,
Thank you. Your honors, with that, I would move to admit SPS stipulation exhibits 1 through 3 into the record.
Mr. Berger, are the questions and answers in your testimony true and correct to the best of your knowledge?
yes.
And did you prepare the attachments to your exhibit, or were they prepared under?
I apologize. I have prepared attachments 2, 3, and 4. The first attachment is a copy of the stipulation and settlement tariff.
So the ones that you did, 2, 3, and 4 were prepared by you or under your direction and control?
Yes, ma'am.
And they're true and correct to the best of your knowledge?
Yes.
And the copy of SPS Exhibit 1, the stipulation, do you know whether or not that's an accurate representation and is inclusive of all documents that might have been attached to the stipulation?
As I looked through it, it looked complete to me. Yes, ma'am.
And did SPS Exhibit 2, did you prepare the reconciliation statement?
I did not prepare that, but I did look at it.
Do you know who prepared it?
Other people in my group prepared it along with legal input.
Do you have it in front of you?
I do.
It's entitled Exhibit B.
Yes.
Do you know whether or not it was actually attached to the stipulation? Will you look at the stipulation?
Right. It was not attached to the stipulation. It was
Okay.
filed separately.
Okay. And the reconciliation statements basically, if I can characterize it, has 4 sections, all of which except one are labeled as not being applicable. Is that correct?
That's correct.
And then the one section that is not labeled not applicable says there's no customers. Is that correct?
That's correct.
So then the representation of this document is that really this particular form of proof isn't applicable to the stipulation, correct?
That's a fair representation, yes.
Okay. Does anyone have any objection to SPS Exhibit 1, the uncontested comprehensive stipulation?
No objection.
Hearing no objection, SPS Exhibit 1 is admitted. SPS Exhibit 2, a reconciliation statement that basically says it's not applicable to the stipulation. Does anyone have any objection to
Nope.
what's been identified as SPS Exhibit 2? Hearing nothing, SPS Exhibit 2 is admitted. Does anyone have any objection to SPS Exhibit 3? Mr. Berger's pre-filed testimony in support of the uncontested stipulation as corrected by him here today. Hearing no objection, Mr. Berger's testimony as corrected will be admitted, subject to its immediate entry into the Dropbox as Berger stipulation testimony corrected. Anything further, Ms. Hardy or Mr. Stewart?
Nothing from me.
Okay. Do you pass the witness?
I do.
Very well. Commissioner Ellison. You had questions, sir, for Mr. Berger.
Yes, I do. Let's see, maybe if I could start out by sharing this PowerPoint screen here. Let me see if I can figure out how to do that. Oh, it looks like I'm not able to do that. Is the screen sharing disabled?
Well, I have the screen sharing, and unless you are the host,
I cannot do that. Okay.
I don't think you can do it, sir. Let me
Okay.
see. If,
Okay, that's not a problem. I'm I'm just looking at the proposed rates for the the 69 kV rates, and Mr. Berger, I was just wondering if you could walk me through how this would work in the case of a cogen plant. I see you have that labeled as a other generators option. If the cogen plant were working at all times, what would the customer pay?
Yes, sir. So under the standby tariff, we have the charges that you pay whether or not you take service. And I think that's what you are asking about. So they will pay, if they're taking service only under the standby tariff, they would pay a service availability charge. They would also pay a monthly meter charge. And then they would pay the standby reservation charge.
Right. I'm looking at, I think it is in the exhibit A towards the end where you've got this comparison. Summer standby reservation charge of 1.54 kilowatt hours per month. And that is 10% of the LGST demand charge, correct?
Okay, yes, yes, you're looking at my attachment 4. I think I'm catching up with you.
Okay, yeah, I apologize. I can't show you my screen.
well, try now, sir. I tried to enable all participants to share it.
Okay, let's see. Oh, it looks like it might. It's yeah, let's see. It's making me jump through some privacy hoops, so maybe I'll just not try to do that.
All right, sir.
So we've got a 10% of the standard demand charge as a reservation charge. And then I'm seeing a backup demand charge that would come into effect if there were an outage.
That's correct.
Okay, and so with that, let's say there were an outage on day 15 of the month, would the customer be charged that standard $15.40 demand charge for the entire month?
No, sir. Within the tariff itself, which is in my attachment 1, it mentions that even though all the charges are listed here, it mentions that we charge the demand charge on a prorated basis.
Okay.
So it's not charged for the entire month automatically. It's prorated dependent on the number of days you take backup service. And in addition to that, it's the higher of the actual backup charge or the monthly standby reservation charge. So you don't automatically pay the backup demand charge.
Okay, and
so you can see that on the screen now that the hearing examiner is sharing on the right side, second backup demand charge underneath option 2 there. It explains the higher of calculation that I just described.
okay, and then I see a September maintenance demand charge and a winter demand charge on this particular chart. So those would only apply in the case of, so you're saying summer maintenance is out, but maintenance in other times is okay, but the September maintenance would cost more.
Yes, September maintenance charges are the same basis as the winter maintenance charges, 75% of the applicable demand charge. The issue here is SPS has seasonal rates, and the seasonal rates for us are June, July, August, and September are our summer months. But we settled on allowing maintenance in September as well as the winter months. And so that's why there is a second demand charge listed for maintenance.
Mr. Berger, do you have any customers in the SPS in your New Mexico territory that have a cogen plant?
Currently, I don't think there are any.
I see. Are there any large customers that have a qualifying facility in general?
There's not a large customer. There is a wind turbine in Tucumcari that I believe is a qualifying facility, but I would have to verify that.
But they would not be eligible for this proposed rate, since the standby rate is as outlined here, would apply to large customers only.
Well, that's correct. And that is also that is just a generator also. It's not a behind the meter generator, which is what this tariff is intended for.
I see. So what is the main impetus here if there aren't customers with qualifying large customers with qualifying facilities?
Well, there are customers interested in constructing behind the meter generators in New Mexico. That's been the impetus to establish a standby rate. And especially, as you can tell by the other signatories, the large customers are interested in it, the ones who are under our LTST tariff currently. And that's why we're putting this together, so there will be an avenue that they would be able to use to get standby service.
Would it be fair to say that you're getting more interest from large customers that are potentially interested in installing solar PV, or have you also received interest from customers interested in cogen plant construction?
I would say it's both, but recently, from what I personally have heard, which I am not fully informed on this, I will caveat it with that. It's been the solar that I have heard about more often lately.
Right. The 10% of the standard summer demand charge, is that a cost-based determination that led you to that number?
Well, we discussed all of these, and which 10% charge are you referring to specifically?
The summer standby reservation charge for the other generators option.
Okay, yes, the same one. Just wanted to be sure, sorry. In my mind, it's below cost because SPS's transmission costs are more than that 10%. As you can see on the attachment we've been looking at, but some of the other parties, if you see prior testimony in this docket, have argued that 10% is above cost. And so during settlement talks, we agreed to use the 10% and say that that is a good proxy for cost, since we had folks on both sides of the equation.
What did you calculate to be the actual cost?
Well, on my stipulation 4 that we've been talking about, page 1 of 3, the top section shows the unbundled production and transmission rates. So our transmission rate would be $5.51 for summer, $4.59 per kW month in the winter.
Yes.
Those would be what I would consider the cost-based transmission charges applicable to this if we used the full cost-based rate.
Which would be the same as you've expressed in your solar option.
That's correct.
Okay. In your view, what's the common sense meaning of the term standby as it applies to rates?
Well, standby service is, SPS has the system here designed to serve all of our customers, but for a customer that builds their own generator, standby means that they will primarily rely on their generator that they've constructed, but whenever their generator produces insufficient power to supply their needs, SPS would supply the difference. And of course, the maintenance service is under here. Whenever they need to take the generator down for maintenance, SPS will have its system available to produce the power needed during maintenance outages.
Is a large customer with behind the meter solar capable of operating in isolation from the grid?
I don't actually know that. I would have to have an engineer tell me if that is feasible. I apologize.
Let's assume that a large customer with only solar PV, so no batteries, is not capable of operating in isolation from the grid. In that case, that would seem to really go against the spirit of how you've defined the term standby as it applies to rates. Wouldn't you agree?
If they're not capable of serving their load completely disconnected from the grid, is that?
If they cannot operate for 1 second in isolation from the grid, wouldn't that seem to conflict with the common sense meaning of the term standby as it applies to rates?
I wouldn't think so, because remember, part of this is we're standing by for the portion of the load that they're serving with their generator or intend to serve. Oftentimes, customers construct generation for a portion of their load. So in those instances, they're going to have to stay connected to the grid anyway. And that's the majority of standby service I have personally come across, is a customer builds a generator to serve a portion of its load. So it's always connected. Now, if I think the situation you're describing is there would have to be a customer trying to build generation to fully supply its load. And that's just not normally what folks do.
Okay, but when I asked you about the common sense meaning of the term standby as it applies to rates, you said that the facility would primarily rely on its own generation.
I did, for the portion of the power that the generator is expected to supply, yes.
Why should a large customer with generation that cannot operate in isolation from the grid be eligible for a standby rate?
I'm sorry, I didn't hear all of that. Could you repeat that?
Sure. My question is just, in your view, why should a large customer with generation that cannot operate in isolation from the grid be eligible for a standby rate?
Well, and again, we're talking just the solar here, I guess.
Yes, let's just assume we're talking about solar PV with no batteries, and let's assume that it cannot operate in isolation from the grid at all.
Okay. Well, we worked on this for quite a bit as a group to come to this settlement. As so, standby, we all believe is doable for this. I'm not saying it's perfect. That's why we designed the time of use rates for it, because anytime the solar generator needs to lean on the system, we make sure that they pay those peak demand costs for it. But so I think the way the time of use rates are structured, it works for the standby services that are provided.
Let me ask a little about, I guess, some of the other aspects of the proposed rates. Your LGST rate has an energy charge of about 0.6 of a cent. Is that correct?
The energy rate?
Yes, the energy charge.
Yes, sir.
And the solar option has an on-peak energy charge of roughly 11 cents a kilowatt hour and an off-peak of roughly 1 cent per kilowatt hour. Can you, I guess, explain some of the thinking that is behind that that difference?
Sure. So at a big picture level, the rates for the on and off peak were designed so that if a solar generator does not operate at all, it would pay approximately the same amount over the entire year as a firm customer. That's how we came up with these adders for the on and off peak rates at big picture. As far as these on peak and off peak rates themselves, they were intended to recognize that, the peak has much more value to SPS's planning of its system and such. So any usage during peak hours has much more value and cost to the other customers. We wanted to make sure this rate recognized that. But in addition to that, there's an adder for off-peak to recognize that, hey, there is cost that SPS incurs for just to have this capacity available during, the nighttime hours as well. And so those costs are recovered during those nighttime hours with that smaller adder.
So is that, I guess, that 11 cents per kilowatt hour, is that designed to recover essentially the what you would consider the generation charge?
Yes, sir. Sorry, I didn't explain that well at all. It is intended to be the generation demand related charges, production, as I label it on this stipulation exhibit of mine. So these are the other production demand charges that are not included in the standby generation charge itself. We designed energy rates to recover the rest of those production related demand costs for a solar generator if that solar generator didn't operate. And so then the solar generator benefits whenever it actually does operate, it doesn't incur these time of use rates. So that's where they get their benefits that they bring.
And so you chose to, instead of recovering the the generation demand through a demand charge, you chose to recover it through a volumetric charge.
Yes, we did. That was proposed by one of the folks in this case. I believe the New Mexico large customer group. And that's because, there's a belief that, solar isn't, it doesn't run the same as I think you're hinting at as other generators. It's not just on at 100% or off. It operates depending on the conditions of the day. And so this rate is intended to recognize that it operates differently than thermal.
And so when you say you've calculated that, under this tariff, I believe you said if the solar plant did not generate, a customer on this option would pay the same as they would normally, correct?
Approximately, yeah.
Approximately. Does that assume a flat load, a sort of a constant 24/7 load for the facility, or did you assume some sort of a load pattern?
It does not assume 100% load factor. These large general service transmission customers are typically very high load factor customers, however. So these rates are designed around an approximate 90% load factor.
Right. I'm more referring to time of use. Like if you're looking at load over a 24-hour period, whether it would be varying by hour or whether it would be flat.
Right. It does.
Your calculations.
Yeah, that's what I was trying to get at. I'm apparently not saying this very well today. I apologize.
No, it's fine. It's not a problem at all. So you're saying there's maybe a 10% variance?
They're usually very high load factor. So yeah, around 90% load factor for our large customers. That's correct.
Okay, maybe a 10% variance throughout the day. One thing I'm curious about, so you've got two cases here, one for solar, which applies to large customers with 2 megawatts of behind the meter solar or more, and then everybody else. If a customer put in 2 megawatts of solar and also put in battery storage, which one of these options would that fall under?
The way this tariff is written, it would fall under solar.
I see. Even though they would obviously have some characteristics of a dispatchable generator.
Possibly, depending how those batteries are sized and able to run. Sure, there could be some characteristics of a thermal, but usually the batteries have a lot of limitations on them as well. So my immediate reaction is the way we wrote this would be under the solar option.
I see. Is there anything stopping a large customer from putting in solar generation now under the existing LGST rate?
No, there's not.
Is it simply that large customers have expressed that that's not attractive enough for them to put in the solar?
Well, it's more folks want to know the paradigm that they will operate under. SPS used to have a standby rate in New Mexico, and it got removed about 7 years ago during a rate case because there was some confusion as to what all was going on there and what was in those rates. And so the large customers in particular are interested in getting standby rates reestablished in New Mexico so that you have more certainty around the costs, as you say, and as opposed to it being just behind the meter generator that you basically get credit for just energy, that the standby tariff would recognize that there are some production capacity benefits to the system so that the customers who do this construction would get the benefit of discounted production rates.
Could they not, under the existing LGST rate, could they not potentially see a reduction in demand charge if, you know, their production is sort of aligned with peak consumption?
Well, it would be very unlikely for solar, especially since that seems to be the main thing we're talking about. Like I said, these customers have very high load factors, 90% type load factors. So the sun goes down. So at midnight, doing simple math, say the customer's load is 1,000 kW during the day, the lowest it's going to get at night, based on the 90% load factor, would be 900. It's really likely higher than that because I'm talking annual load factors when I say 90%. So it's not going to go down much at night. And so under the standard large general service transmission tariff, they would end up paying those full demand charges still because of the fact that their load is on at night.
So because the I guess the hourly load profile of these large customers doesn't vary that much, putting in solar would not help to reduce the demand charge.
That's correct.
But obviously a cogen plant would be a different story, something that could operate 24/7.
That's correct. Then their big concern is maintenance and such, which was a big part of our discussion during settlement talks as well, as to getting that right for the other type of generators.
Right. The energy charge of approximately 0.6 cents per kilowatt hour, does that reflect the average market price of power on your part of SPP, or is that reflecting some I guess it's more complex than that. I'd just like to hear what it's what determines that energy charge.
Sure, it's actually simpler, I think, than where you're headed. It reflects SPS's production-related variable O&M costs. So it's when we went through a rate case and we functionalized all our costs, we had production, and then we had the variable production-related cost and the demand-related production cost. And so we have those two buckets, and this is the variable O&M of SPS's cost. It doesn't have anything to do with the market or fuel costs. This is purely non-fuel variable.
So customers are going to have a fuel and purchase power cost adjustment that is in addition to this.
Yes, sir.
Okay. I was just thinking that's pretty darn good. 0.6 cents per kilowatt hour. And I would guess you've got so much wind that helps drive that number. In your Texas service territory, is there a standby rate for large customers?
Yes, we have a standby rate in Texas.
Does that apply to customers with behind the meter solar?
We have not made a behind the meter solar option at all like what we are doing in this case. It technically, given that we haven't made an option for solar, it is applicable to solar, the one that we have in effect, because it's got one option that applies to everybody.
Mr. Berger, if you're familiar, do any of the other Excel territories have a standby tariff that is available for solar?
I actually don't know that. I wish I did. I don't know if they have a standby for solar or not. We could check.
Consider that a bench request, Mr. Stewart, Ms. Hardy. I'd like for you to submit what standby rates that the other Excel jurisdictions have. Thank you. Go ahead, Mr. Commissioner.
Sure, and I guess this brings me back to one issue. I recall that in the previous rates that SPS had, the standby rates that were rejected, as you had mentioned some years ago, there was a clause that if a customer took so many hours of power from the grid, that I believe for that month, they would revert back to the standard LGST rate. Is that correct?
That is the design that one had. It worked a bit differently than this one for both types of generation. Yes, so that was a threshold of if the generator was below 60% of its capability, that counted as a usage hour. And once you exceeded that number of usage hours under that tariff, you would revert to the full rates instead of the standby rates. But in the meantime, you weren't charged any daily demand charges or anything like we've designed this one. So this one, instead, you don't have usage hours, you just have the prorated daily demand charge on option 2, and you have the time of use energy charges for the solar.
I see. So, right, I'm looking at, I believe it's your previous tariff. It says if customer usage hours exceed 120 usage hours, the above charges shall not apply, and the customer shall pay the applicable tariff rates for all demand and energy supplied by the company. Further, customers shall not be eligible to take service under the standby service rider until June 1st of the following calendar year.
Yes.
Does that sound familiar?
That sounds familiar, yes.
Yes, okay. So with the structure being proposed here, there's no such sort of a threshold. If a customer is on the standby rate, they wouldn't be kicked back to the standard tariff due to how they perform. Is that correct?
Well, that isn't quite correct. We have a different test in here now that we agreed to. I discussed this in my testimony a bit. It's under the definition of contract standby demand or standby capacity. So what we've done in this new tariff is in addition to the charges that we've been discussing, each year, once we get past the summer, this is the last couple of sentences of the definition of contract standby capacity, we will look at the generator's maximum output in June, the maximum output in July, the maximum output in August, and the maximum output in September, add those together, divide by 4, and that's the maximum that this customer can have as standby capacity for the next calendar year. So if the generator does not operate during the summer, or it doesn't operate very well, similar to the old construct that you're reading from the old tariff, we will reduce the amount of standby for the next calendar year. And then that essentially means they have to get that generator up and running, and we'll do the same test the following year. And if it meets the test where it could increase the contract standby, then it would go up again. So
Would that apply, Mr. Berger, to both the solar option and the other technology option?
Yes, it does.
It does. Okay. Are you familiar with the standby rates that El Paso Electric and P&M currently have?
I am aware of them. Saying I'm overly familiar with them would be an overstatement, but I have read them.
That's fine. Do they offer separate rates for solar generation?
They don't. They read to me as old, as I would call old tariffs for QFs under PURPA that came out in 1978. You know, there were a lot of standards that came out 45 years ago, and the world is changing a bit. And so that structure, which is actually consistent with what we originally proposed in this case, to me is personally is getting a little outdated. Those old PURPA tariffs that only apply to QFs, because technology is a lot different than 45 years ago.
That reminds me, one other question. Let's assume we've got a solar generator in one of your large customers. They're probably going to send power back to the grid during the day. What price would that power be purchased at, the qualifying facility price?
Yeah, yes, that's covered towards the end of the standby tariff. We call it the excess energy, I believe is what it's titled. Let me find it here. Excess generation, it's the next to last section in the tariff. So if the customer is a qualifying facility, or if they've registered at FERC as a qualifying facility, they will sell any excess to SPS under our qualifying facility tariff rate number 4. And if they are not a qualifying facility at FERC, they will need to negotiate with SPS as to how that energy is priced.
Okay. So, you know, you've mentioned that the transmission charge for the solar option is lower than you know, you believe would be cost-based. Have you calculated the level of subsidy that we're talking about? Aren't we in effect talking about a subsidy from one group of customers to another?
I actually don't believe that's what I said, Commissioner. It was the other way around. When I said the standby reservation charge was below cost base, that's when we were talking about option 2.
Yes.
The option 1 transmission charge applicable to the solar generators is equal to the unbundled transmission demand charge. I think that's shown on that page 1 that we're looking at.
Right, I see. So I guess then I'm more okay. So I guess there is that issue with the cogen that the reservation charge for transmission appears to be a lot lower than cost. But your summer and winter backup demand charge seem quite high. Is that to compensate for that issue?
Well, these charges were all set to try to comply with Rule 570, essentially, New Mexico Rule 570. So, and again, I don't mean to imply that the rates we settled on are that the 10% rate isn't cost-based. I was trying to point out that from our perspective, it was below cost, which is what caused some of the disagreement during talks, but other parties have filed that the rate should be less than 10%. So, it depends on who you agree with, whether this is above or below cost. So I don't want to overstate 10% being above or below cost as part of the settlement we reached here.
Okay. But I guess going back to the solar option, the large customers installing solar would be getting a discount as compared with what they would get on the LGST rate. Is that correct?
For the production demand related charges, that's correct.
For the production.
It's intended to recognize, that when that solar generator does operate, that they get those production related benefits that they bring to the system. That's exactly the point of the settled rate.
So, Mr. Berger, is it correct then that you could say that they're getting a benefit because they're adding some kind of credit to capacity? That SPS would not have to go and provide peak generation power during that period?
Currently, SPP does allow SPS to treat behind the meter generation in most instances as a reduction to load. So yes, as long as that is operating at peak, we would expect that SPS could plan for the future years at a lower production demand. Yeah.
So I guess the crux
Thank
of my
you.
question, I'm sorry, I guess the crux of my question is, so when you've got a large customer that puts in behind the meter solar, is that actually dropping SPS's costs to have generation on the system?
Well, we of course don't have any of these customers out there yet, so it's hard to say definitively, right? But based on the discussions we've had with the other parties and reviewing some of the presentations they had around how the solar operates, yes, we expect some reduction to the production capacity related cost of SPS because we do expect them to be on typically at the peak hour. Now, will it be on at its full capability or not? That's what we still need to learn once some of this is constructed, to where we could really hone in on what is the proper amount of credit to give, a solar generator with behind the meter solar generator. But we've negotiated this based on, expected outcomes, because that's the best we have for now. And we do expect the generator to be online during the peak hours.
So I guess to the extent that the cost to SPS for generation procurement do not drop, and these new customers with behind the meter solar would be paying less, would that not mean that there would be some subsidy from customers who are not on this rider?
Well, with that assumption, assuming that this generator didn't operate on peak, yes. But remember, we talked about the test that this tariff has built in it. So it's a self-correcting problem. That's why we have that test in there. So this isn't a permanent issue. It's if the generator really isn't on during those 4 peak months to where it is contributing to a reduction in our production planning peak, we will reduce the contract standby going into the next calendar year. So if there may be a temporary mismatch, but the point of the test is it's a self-correcting tariff.
Was the question of whether there might be a cross subsidy one that was of concern when developing this tariff?
Yes, it's very much of a concern to SPS. Me in particular, I was during those negotiations wanting to make sure that we could have a tariff designed to recognize the benefits behind the meter generators bring, but not at the expense of our other customers. So that's why I think this is important, that it has this self-correcting mechanism.
What would be the ramifications of not having a standby rate, of continuing to not have a standby rate?
Well, obviously, the customers who are interested in constructing standby generation would not have the clarity that they need to do it, I think, is one. Two, I'm not a legal expert, but even though I believe EPE and P&M's tariffs may be somewhat outdated, I personally feel like under the QF rules from PURPA, we need a standby rate. You know, under all the rules from federal and state, I think we need one. And so I think we're out of step for the last 7 years by not having one. I'd have to have attorneys verify that, but that's my personal belief.
Could the and this is, you know, again, just hypothetical, could the commission accept the one of the two cases, say the commission agreed with the other case but disagreed with the solar case, for example? Could we strike one of the two cases and adopt the rest of the proposal?
Well, of course, that the commission always has the prerogative of saying what it will and won't accept. The parties, as you tell from reading our uncontested stipulation, believe this entire stipulation should be accepted. We worked hard to get all of us on board both options. We think both options are important to have because there are customers interested in both options. So I don't think that would be the right way to go. I, of course, would never say the commission can't do something.
No, I fully appreciate a lot of work has gone into this, and thank you. I think those are all the questions I can think of for now.
Thank you, Commissioner. And I think, given that we are at the 10:30 mark, I think we should go ahead and take our recess, and we'll take a 10-minute recess. I have 10:32. We'll come back in 10 minutes, and we will begin if anyone has any cross based on the commissioner's questions. Well, let me think about that. We'll come back in 10 minutes and we'll continue our evidentiary hearing. Okay, I believe we are at our time. And I think probably what's going to make most sense is just to have one cross response to the questions. Generally in uncontested stipulation cases, there is no cross-examination from the parties, and the parties are given an opportunity to examine the witness on questions from the commission or the hearing examiners. So I believe what's going to make more procedurally more sense is for the hearing examiners to go ahead and ask their questions at this point, and then the parties will be able to ask any cross that they may have based upon that. Any objection to that procedure? Hearing none. Commissioner Ellison, did you have any before we go ahead? Any further questions at this time?
No, I think I'm fine. Thank you.
All right, very well. Hearing examiner Allen, you had some questions for Mr. Berger?
Yes, I do. Thank you very much.
Thank you.
Commissioner Hurst, hearing examiner Hurst. Good morning, Mr. Berger.
Good morning.
I wanted to, I had a few questions around Rule 570. I think primarily what you referenced during your testimony. And in 570.6, it talks about the objective for Rule 570 governing cogeneration and small power production. So, and it indicates that in particular, there's an intention to simplify metering procedures for qualifying facilities up to 10 kilowatts. And how does the stipulation achieve that, if you could tell us?
This doesn't address the small ones that currently there will still not be a standby tariff for the small customers. They are just treated as netting out their charges to their kilowatt hour charges.
Okay. And so can you describe the size that is affected by this tariff?
I would expect this to be a megawatt or larger. If a customer is going to construct a behind the meter generator and you're a large general service customer, these are generally larger loads. And so I would expect them to be a minimum of a megawatt generator. It's not required that it be that large, but I just personally expect that would be the size.
All right. And I know you had indicated that you didn't believe that there would be any customers currently in your service area in New Mexico. Would there be or are there customers who would qualify and well, they wouldn't obviously qualify for a New Mexico rate, but would you have customers who might qualify for something like this in Texas if it were available?
We do have a few, not many, but a few standby service customers in Texas.
And is there a standby rate in Texas that applies to those customers?
There is. We discussed earlier, there's not a specific option for solar. So the standby tariff in Texas applies to any type of generation. There isn't a specific rate designed to help deal with the unique qualities of solar generation in Texas.
And what type of generation are those customers
They,
utilizing?
my understanding, I haven't researched this month, but my understanding is they are all thermal generators that are currently on the Texas standby rate.
Okay. And were you involved, I guess, in the original stipulation that discussed developing a standby rate focused on the needs of solar customers?
I was not. I came into this case fairly late as well, but I was not part of the settlement in the rate case.
But in developing this stipulation, was there a decision to focus on the solar customers?
Well, we all recognize that was part of what we agreed to in the rate case, right? When we all sat down in March, without giving too much away of what we all talked about, we knew that was one of the key things we were supposed to accomplish, a standby tariff that had a solar option. And so we worked hard to agree on a standby tariff that had a solar option that we all thought was a viable option where it would work for the customers and it wouldn't create cross subsidization issues.
And you're familiar with Rule 570?
I have not memorized it, so you may have to show me sections if you want to quote it to me, but I have read it.
And so, Rule 570 does require the provision of a supplemental backup maintenance power to qualifying facilities. Is that right?
That's correct. And this tariff is a little broader than that, as in we don't require you to be a qualifying facility to take service under this tariff. So in that sense, this is a little broader than Rule 570.
Okay. And how would you understand a qualifying facility to differ from what is permitted under the proposed stipulation?
Well, a qualifying facility is a special, I don't know, special is the right word, but it's a generator that goes to FERC and registers as a QF, and FERC has a bunch of requirements for what it takes to become a QF. So FERC generally sets all those. I don't have all those memorized, but it's generally a size limit, or if you're a cogeneration facility, you have to be some sort of industrial use or some limit to your size or what to become a QF.
Okay, so these facilities might be qualifying facilities, but they may not have gone through the FERC process.
That's what I'm expecting is, again, things have evolved in the last 45 years. So a lot of these folks could register as QFs, but there may not be any reason for them to go through that paperwork at, where we're at now. There's not necessarily a need to do that.
And will the stipulation encourage behind the meter generation by individual companies or property owners who might fill or fit into the size intended by this tariff?
This tariff is limited to the large general service customers. We worked hard to get this much done. The parties weren't able to go beyond this in the time we had to try to work on a standby tariff for other classes. In this case, SPS still believes it's appropriate to have standby service rates for other classes, but we are trying to get focused on what the parties think is of the most immediate need. And the large customers are the ones who have expressed interest of constructing behind the meter generation in the near future. And so we really wanted to get this one done.
And so will this tariff result in a lower cost for those customers than if they just paid the normal rate?
If their generator operates as expected, it should. That's the purpose of the rate design that we've agreed to, is if their generator functions well, they should receive lower rates than under the firm rate.
I had a couple of questions about the exhibit 4 attached to your testimony.
Okay.
So you were saying that the transmission costs included in this exhibit are cost-based, 551 and the 459.
Yes, that's correct. Those are from the previous rate case that you alluded to from that settlement in that rate case. The total demand charge is the 1540 and the unbundled production is 989, unbundled transmission 551. Those add back up to the 1540 that were from the settlement rate, similar with the winter charges. So those are the rates from the last rate case.
Okay. All right. And can you explain how the 10% was derived from these figures?
Mathematically, or?
Well, it's actually the 1540, right, is the summer demand charge. And so the 10% is the $1.54.
For option 2, that's correct. Yes.
Okay. And so comparing that to the transmission charge, I guess what I don't fully understand is between, the 551 summer standby transmission charge and the $1.54. What's, if any, relationship between those different figures between the solar and the other generators?
There isn't really a lot of relationship there. We worked on the settlement talks based on what all the parties had proposed earlier in the case. And folks had proposed a solar option and a non-solar option, and they proposed it with 2 different rate structures. We settled on 2 different rate structures, so there isn't a direct relationship between the 2 options.
Okay. I think those are the questions that I had for Mr. Berger. Thank you very much, Commissioner Hurst. I'm sorry, Examiner Hurst.
You're on mute, Your Honor.
Oh, Examiner Hurst, you're on mute.
Yes. Thank you. Thank you for that elevation. Hearing Examiner Allen. I've got a few questions for you, Mr. Berger. And I guess since I have this up, hopefully I am, it says I am sharing the screen.
Yes.
So let me just start where hearing examiner Allen ended and ask you, if I'm understanding your testimony, the agreement in both answers to Commissioner Ellison's questions and hearing examiner Allen's questions, the 10% agreement was sort of just that, correct?
It was an agreement, and it was also intended to recognize the limitations of Rule 570. So it was both.
And you indicated to Commissioner Ellison that you were familiar with El Paso Electric and PNM's standby tariff. Is that correct?
As I think I mentioned him, I have read them. I won't claim I'm an expert on them. So yes.
Do you know whether or not that because the Rule 570 section says that that the utility can charge up to 10%. Isn't that correct?
That's my recollection, yes.
Okay, so it's a ceiling, not a floor, right?
That's correct.
And if you know, do you know whether or not both the SPS and the EPE tariffs also chose the 10%?
It's my understanding they are both at 10%.
Okay. One thing that also has been an issue, both in the litigated case that still lingers in mind, Mr. Berger, and I know that you have indicated that you were at least brought in for your expertise in dealing with the stipulation and the testimony in this case. You didn't testify in the litigated version previously of this case, did you?
No, I did not. I didn't get involved in this case till after the recommended decision was issued.
And you've indicated in your response to Commissioner Ellison and hearing examiner Allen that what precipitated this particular case was in fact a section, and I would refer you to section 10C of the stipulation in case number 20-00238, which was SPS's last completed rate case. Is that correct?
Yes, it is.
And that particular section of the stipulation, SPS didn't file any standby rates in that rate case, did it?
No, we did not.
And the case where the commission rejected your the standby rates that you had and that you proposed to change was in case number 17-00255. Is that correct? If you know.
That case number doesn't ring a bell, but I have no reason to doubt that you're correct.
Okay, that decision was in, I believe, finalized by the commission in 2018. Does that sound about right?
That timing sounds about right, yes.
Okay. And let's see. And yes, it was appealed. I realize that, but I'm just trying to get to when the commission filed that. And do you know whether or not SPS had a rate case between the 17,255 and the 20,238?
I can't recall off the top of my head. I apologize. I could check.
That's fine. That's fine. I'm just trying to figure out it. Did you participate in the rate case in 20-00238?
I did. I participated on some fuel related matters.
Okay. Do you know, did SPS propose standby rates in that case?
My recollection is we did not, that was proposed by other customers in the case.
Well, if as you've said it, that you think your testimony here today is, that you think that standby rates are pretty important for rural, both state and federal compliance, then after the rejection of your standby rates in 17,255, why didn't SPS file standby rates in your rate case in 20-00238?
That's a interesting question. I'm not certain of that. I wasn't running those cases. I do know that a big reason that I was brought into this is I had some history with our older standby rates, as we've discussed today, and that the company wanted to come up with a reasonable solution with all the parties. So they asked me to work with everybody here. So I know that part. I don't know exactly why nothing was filed in the prior rate case.
Okay. And as you point out, it was the other parties in the rate case that proposed a standby rider, and that based on the testimony in that case, SPS did not agree with. And ultimately the resolution was, Mr. Berger, a stipulation in that case where the parties agreed that they would confer and file within a period of days of the commission final order in the case that a proposed standby tariff that included a solar option. Is that correct?
That's my recollection of the settlement, yes.
And you read the recommended decision that hearing examiner Allen and I issued in this case at the end of February, Mr. Berger?
Yes, I did.
And one of the issues that we had was SPS's response or lack of response in our findings regarding that particular provision of the stipulation, correct?
Yes, I remember reading that.
Okay, so I guess my question, Mr. Berger, is since there's been an obligation since the last rate case final order for SPS to discuss these issues and try to come up with some kind of tariff. Why did SPS wait till March of this year? Almost a year from when the final order was issued, to get down to brass tacks.
I'm not certain how the talks went prior to filing this case, since I wasn't involved in. I read the testimony and such that said we reached out to parties. I don't know exactly how that went. I also know that a lot has changed in that year, so maybe that's what changed along the way, or maybe it's just the timing of the case didn't allow folks to get together and really talk settlement, since I wasn't involved in it until after the recommended decision. I don't know what the timeline was and what time it allowed for settlement. Yeah, it's hard for me to speculate on how we got where we did. All I know is when my boss came to me and asked me in March to, hey, can you look at this, get up to speed on this case and see what you can do to work with the parties to get to a settlement. And that's what I did. And so, and thank goodness we were able to get to a settlement. So.
Sounds like maybe you should have been involved a year ago, Mr. Berger.
Well, I don't know. Maybe a year ago we wouldn't have had as good a luck, because we all wanted to come to a settlement after your recommended decision. So I think that gave all of us the impetus to want to get somewhere.
I'd like to look at page 4 of your testimony, Mr. Berger, and I just need some clarification, sir. The questions posed at line 3, please provide an overview of the stipulation, and at lines 1 through 10, you do that. And specifically at line 7, you say the settlement tariff has an option for behind the meter solar generation and an option for other types of behind the meter generation. Is it my understanding then that option 1 is for solar only, and that no other type of behind the meter generation could fit in that particular tariff?
That's the intention of the parties, and that's correct.
And why is that?
Well, we worked hard on designing those rates to where they would work for a solar generation facility. As I discussed some with Commissioner Ellison, the on-peak rates and off-peak rates that we settled on are intended to work in the manner so that the solar generator receives the benefits that he brings to the system, as we all agree to. And if you start applying that to other types of generation, it's not immediately apparent that these rates would work for that. So we limited it to the solar generators we designed it for.
So then is it my understanding that all other types of generation would fall under option 2?
That's correct.
So as you and I are both probably familiar, SPS has some wind farms, correct?
Yes, we do.
And you got kind of a big one in eastern New Mexico.
Yes.
Correct? And so if that wasn't owned by SPS, which it is, correct?
It is.
And I'm talking about Sagamore, correct?
Yes.
Say someone else owned it and it was providing for part of their generation, they would fall under proposed option 2, correct?
Well, not the way Sagamore was constructed. It again is not a behind the meter generator, but if a customer constructs wind, behind the meter, we did not settle on a wind option for the standby tariff. We have just solar and everything else. So that's correct.
So if I had a behind the meter, if I was a large SPS customer that was transmission level, and I put in a big installation like Sagamore, I wouldn't be able to use either option.
You can use option 2. I apologize if I misspoke.
Okay. So I could use option 2, but aren't my wind or are my wind characteristics similar to the solar characteristics?
I would personally argue not, that they are not, because wind, from what I have experienced, tends to blow a lot more consistently at night than during the day. There's a little bit of, not completely, but a little bit of inverse relationship there. Solar tends to reach its peak during the day. Wind tends to reach its peak at night. That's not true every day for wind. Wind, as you know, wind comes and goes. It isn't as dependent on the sun. But it still tends to be there more often, more consistently at night than it is during the day.
So then if in my hypothetical, then if I was this behind the meter wind generator, you know, am I going to get the adequate rate consideration for my contribution, my generation contribution to SPS?
Well, I would say yes, because of the fact that the savings that SPS gets are related to the generation during the peak, as we've discussed some earlier, which is why we structured the solar rates the way we did. So given that wind isn't nearly as dependable at peak, unless you had a lot of wind behind your meter, it's going to be difficult for it to offset your load. And that's sort of the point, right? If the generation is not offsetting your load at peak, we don't want to be giving you a discounted rate. So I think it works. There isn't a specific wind option, and we could perhaps look into developing one, but I don't see any reason that this can't work.
Okay. And would your answer be the same whether any type of renewable generation, if it was, biomass or whatever the proposed renewable generation could be?
I wouldn't say for any, that's a pretty broad thing. I try not to speak in absolutes, but from what we're aware of now and what the parties discussed of what folks were interested in doing, I think that this tariff accomplishes what we wanted to accomplish for now. Now, if something new comes along in the future, we can always add a new option. I think that we don't need to feel like just putting this tariff in place now means we can never add options in the future.
I'm just wondering whether or not this proposed tariff excludes anybody.
It's not intended to exclude anything. That's why it's the solar, to make sure everybody is clear that it has a solar option to, like we committed to in the rate case you mentioned, and it has the all other option. But if it turns out that the all other doesn't work fine for everything, we can always add more options.
And why is the other option described as a thermal option?
I don't think it is described as a thermal option, is it?
Well, it's not specifically, but it seems like when people are talking about it, they refer to it in their testimonies as thermal generation.
Well, maybe it's because in the earlier part of the case, that's what they were considering constructing. And so they said, oh, this will work for us doing thermal, and it also works for the solar. That would be my guess.
How do you define thermal generation?
My layman's definition, because I'm not the best at defining it with engineering terms, is just that fossil fuel would be the simple way of thermal, some version of fossil fuel.
Okay, so we'd be talking about like a natural gas or steam or
Most
something.
likely, yes, most likely it's some sort of natural gas cogen would be the normal thermal that you think that immediately comes to mind.
Sir, let's go on to page 9 of your testimony. On page 9, at lines 8 through 9, the question posed is, please discuss the first 3 sections of the settlement tariff: applicability, territory, and availability. And just generally, you answer that lines 10 through 17. And I wondered if for the record, you would describe the difference between a transmission and a non-transmission customer.
Sure. SPS's transmission customers are required to be served at a voltage level of 69 kV or higher. That's the main differentiator. And of course, what comes along with that, as we've discussed today, is those customers tend to be large. But the requirement is 69 kV or higher.
Okay. And large is in reference to how much energy they actually use.
The demand and energy, yeah, they tend to be our larger customers.
And just for clarification purposes, my understanding, your testimony here today is that SPS in its New Mexico jurisdiction currently has no large customers that have any behind the meter generation of any type.
That's my understanding, yes.
Further, on page 10, sir, you're answering the question posed at page 9. Please discuss the purpose, line 18, of the definition section of the settlement tariff, and you begin answering that on line 19. And carrying on page 10, and lines 1 through 5, and you say at the end of line 1, and the signatories agreed on a solar option and a non-solar option. This tariff is more complicated than most retail tariffs. That's your testimony, sir?
Well, I was trying to explain why this tariff has a definition section. Most of our tariffs do not. And so that's what this sentence is trying to say, is given that it has 2 different types of services under it, and that we're providing, because it has 2 different types of services, backup and maintenance, and there are 2 options for those services, solar and non-solar. It's more complicated than most our tariffs, so the signatories thought it would be good to create a definition section that is lengthier than normal by far, to try to clarify how this tariff works.
But you're not necessarily proposing any new or different service than you are, for example, to your rate 34 tariff, are you?
Well, the new or different service is the standby and maintenance services. As far as electrically, no, we're not providing anything where the power flows any differently. We're just providing backup and maintenance services under the standby tariff.
Further down on the page, the question posed at line 13, please discuss the definition of contract standby capacity you begin your answer on line 14. The contract standby capacity definition sets out the limits for the initial amount of standby service SPS will provide under the settlement tariff, correct?
Yes.
And this just might be a language difference, sir, but if one of the options is you're going to have to serve their whole load, how is that a limit?
Well, it's a lesser of type of thing. So it's a limit of, if you build a generator that's a 30 megawatt generator, but your load is only 10 megawatts, I'm not going to stand by for all that extra generation. I'm only standing by for your 10 megawatts of load. That's how the load
Okay.
becomes a limit.
Okay. Page 11, sir, you're continuing the answer of posed on page 10. Please discuss the definition of contract standby capacity. And this is page 11 at the bottom of the page. Line 15, because contract standby capacity is limited to the KW output of the customer's behind the meter generation facility, likely available during peak hours and may be modified annually, SPS's customers on non-standby tariffs are much less likely to subsidize service to standby service customers. That's your testimony, sir?
Yes, it is.
And why is that? Is it because that you're going to know in advance how to build them appropriately?
Well, this is the test that I discussed further up on that page, and I discussed earlier with Commissioner Ellis, and this is the construct in the tariff that I think makes it self-correcting of the generator goes through it, and in the summer months, we measure how much is there in June, how much is there in July, how much there in August, how much there in September. And we take that average, and next year, that's the limit, right? So the first year, you're limited to your nameplate, but then we start using actual operating history to create the limit. And that's what I think makes this a self-correcting tariff.
Okay. Next page, sir, page 12, please discuss the definition of qualified scheduled maintenance periods. And so you're doing that from lines 2 through 15, and you reference on line 14, the 30-day minimum required for QFs under Rule 570, correct?
Yes.
Why is there a 30-day minimum?
I have no idea, since I wasn't there 45 years ago when they wrote all this, but my belief is there was a concern that that utilities weren't going to want to, help out QFs appropriately, right? And so I think they wrote into the laws that, hey, you have to allow maintenance for a minimum of 30 days because, that's a reasonable amount of time for a generator to be down for maintenance each year. That's my layman's belief of just reading these laws years and years later.
Do you have any knowledge about averages or frequency of generator maintenance?
Not a ton. I've reviewed a little bit here or there in rate case filings, but I'm not very close to it. I'd have to talk to our energy supply folks.
Well, I know one of the, well, I don't know if I want to call it a concession, but one of the terms that you all agreed to was to actually agree to 60 days, correct?
That's correct.
So, I mean, double the potential maintenance time. And I just wondered if, you know, if there's more maintenance going on, or if this is just, you know, something that was put in to provide more flexibility.
Well, in some ways, it was intended to be a little more flexibility, especially since we did agree on it being in the off-peak months. Once we were able to reach that agreement, it was a little easier to expand the amount of time maintenance is allowed, because we could be more, we as an SPS could be more comfortable that the generator would be operational during the peak months.
And just so the record's clear, sir, on page 15 of your testimony, line 9, the question posed, please discuss the standby generation charge. And at line 10, you begin your answer. The agreed upon standby generation charge is 10% of SPS's production related demand charge applicable to the LGS-T customers under rate 34. This rate is consistent with Rule 570. That's your testimony, sir?
Yes, ma'am.
And the underlying premise is that rate 34 is cost-based because it was approved in the last rate case? Case number 20-00238?
That's correct. Yes, ma'am.
Sir, your testimony on page 18, the question imposed at line 3, please discuss the backup demand charge. You begin your answer on line 4. The signatories have agreed that this will be the higher of the monthly standby reservation charge or the otherwise applicable LGS-T demand charge multiplied by the customer's daily demand and prorated by the number of days the customer takes backup service in the billing period. That's your testimony, sir?
Yes, it is.
Well, why is this variable and who does it benefit?
Well, I think some of the parties pointed out in their testimony earlier in the case that especially when they were arguing about the thermal generators that we discussed, that you're not supposed to pay both the standby charge and the backup charges in the same month for the QFs under Rule 570. And so this is intended to recognize that of every month you pay the standby charges, and in the months that you use enough backup power that your charge for that exceeds your regular monthly payment, you pay that instead of the standby reservation charge.
So it's a benefit to the customer that they don't get double billed on the same charge, but it's a benefit to SPS that they're going to be fully compensated for their cost?
Well, that's the point, right? Is if the customer does actually use backup service, and especially in a simple example, say they used it for the whole month. Well, instead of charging them standby for that month, we charge them the full firm rate for that month. So then they're treated comparable as any other firm customer. And the customer doesn't pay both charges and SPS receives the full rate. So that's the thought.
I had further on down the page, sir, I had a question why there were a couple of definitions that were utilized in Exhibit A that hadn't been defined. And so you're telling me why that those were not included. And my question was there any objection to putting in a definition for the backup demand charge?
I don't know that there's an objection to it. I think that it's already defined where it's at. And then maybe that's part of why we didn't see any need to, because it explains it's the higher of this or this, and the other two are already defined. And so I'm not sure what else we would put as a definition other than it's the higher of A and B. So it can be, it wouldn't ruin the tariff by any means. I just don't know that it's necessary.
Okay. Sir, page 19 of your testimony, the questions posed at line 14, you're discussing the remaining sections of the tariff, and that begins on line 19, goes on to page 20, and lines 3 through 7, you're discussing the meter installation section. And the meter installation section is specific to the settlement tariff and requires SPS to own, operate, and maintain the metering equipment for service provided under the settlement tariff. That's your testimony, sir?
Yes, it is.
Why?
Well, this was a topic that I don't think was discussed earlier in the case, but it did come up during our settlement negotiations of exactly how are we dealing with the second meter, because we already have a meter for the load, that'll be there, but we're going to have to put in a meter for the generator. And so this meter installation section, as we talked through it, we were debating, well, should SPS always own it? Should the customer own it and we just have access to it? How do we want this to work? And we came to the conclusion that SPS should own the meter, and we came up with this rate for it. And that's the monthly meter charge that I discussed a couple other places in my testimony. And I think it's also in my attachment Stip-2.
Yeah, like I say, I'm just wondering why it makes a difference if SPS owns it or they own it.
I don't know that it makes a difference from our perspective. It's for clarity, and this way we know. In Texas, we have a much longer meter installation section, which has a bunch of caveats. The customer could own it in certain situations if the company decides it's too difficult for it to put the meter where the customer wants it, that sort of stuff. It got very cumbersome and complicated. And honestly, when we talked through it as a group, we decided to cut out that whole extra paragraph or two of complication. So.
Okay. And just so I understand your testimony, lines 21 or pages 21 through 22, where you're talking about the different scenarios of usage. The under scenarios 2, 3, and 4, supplementary power is always provided under rate number 34. Is that correct?
I think we just lost the witness.
Mr. Berger?
I'm back now. I thought I had lost everybody for a moment. Something just happened with our connection there. I'm sorry.
Okay, did you hear my question?
No, it froze up just as you started your question. I apologize.
Okay, I was just asking about the pages 21 and 22 of your testimony, specifically with regard to the second, third, and fourth scenarios. That was it true that supplementary power was always provided under rate 34?
Whenever SPS provides supplementary power, it will be provided under rate 34. Yes. Yeah, in those scenarios, we aren't always providing supplementary power, because there are instances that in those examples I gave that the customer is receiving all of its needs from its own generator.
All right, sir. Thank you. That's all the questions I had for you, Mr. Berger. Commissioner, any further question before we go to the cross?
If you wouldn't mind, I did want to ask just a couple.
Yes, sir.
Let's see if I have any more luck with my screen sharing. Let's see, are you able to see that PowerPoint that I've got up there?
It's up there, but okay, now I'm starting to be able to see it. Okay.
Okay, it's the same rates that I guess were shown earlier towards the end of the Exhibit A, I believe. If we look at the solar option for the 69 kV, we've got the summer standby generation charge of 99 cents per kilowatt per month, correct?
Yes.
Okay, and maybe just to take a step back, at the top of the screen, we've got the LGST rate number 34, and that summer demand charge is broken up into a production and a transmission charge. Could you describe how that production charge works? Is that something that SPS pays, or what exactly, how does that work?
Sure, that production charge is the SPS system average production demand related costs that have been allocated to the large general service transmission class in the last rate case. So we take all of the production related costs that are functionalized as demand. They've been allocated to New Mexico with jurisdictional allocators. Then we use the class allocators to allocate amongst all the classes, including LGST. And we divide by the billing determinants, it results in this $9.89 per kW month for production demand charges. Maybe more detail than you wanted, but those are the steps it goes through to get here.
And so that reflects the capacity, the generation capacity that you need to serve peak load. Is that correct?
Yes, sir, that's correct.
And that capacity is owned, or you've got a PPA for it, or do you sometimes go out to SPP and procure that peak energy?
Well, the capacity is all exactly at capacity. So it's either capacity owned by SPS or purchased under long-term purchase power agreements. If we go acquire energy from SPP, that's just through their energy imbalance market that they now call the integrated marketplace. That is meant to be an economic energy exchange as opposed to capacity.
Right. I see. So, what I'm getting at here is that, this sounds pretty long-term. The PPAs you have in place for capacity, as well as the plants on your balance sheet. So if a large customer puts in solar, it doesn't sound like you're going to be able to easily drop the amount of capacity that you've got contracted for on your system. Is that correct?
Well, that's correct. Of course, it's also correct that SPS is looking at being short production capacity in a few years. So this tariff may actually have good timing if there are customers looking to build generation and they time it with when we're looking to perhaps be short. It could help us avoid purchasing or constructing some of that capacity in the future.
Right. So, when you've got, as you've said, when you've got a large customer, they have generally a high capacity factor. I believe you said about a 90% average capacity factor, such that, their hour to hour load is not varying that much. Is it so? If you've got a large customer who installs solar, how much is that going to actually drop your peak load?
Well, that'll depend on how well the solar facility operates. Some of the information that we looked at during settlement talks is that on average, we would expect the solar facilities to, be able to generate 70 to 80%, during most of the peak hours, and it can get higher than that during some of the peak hours. So a decent sized percentage of their nameplate, so to speak, can be expected to be there during peak hours. So then for the customer sizing this, they have to decide then, well, how big do they build this relative to their load so that they could get the output out of that facility that meets the amount of load coverage they're looking for.
And so basically, even though the load on these large customers is relatively flat, your overall system does have a evening peak, and in some cases you're saying that this solar generation would help to reduce that evening peak?
During the summer time, SPS tends to peak in the late afternoon, early evening. Yes, so say somewhere between 4 o'clock and 6 o'clock Central Time. We tend to peak right in that window during the summertime. And so that happens to be normally a good time for solar to be producing. And so we would expect this to be on at a fairly high percentage of what it was constructed for at our peak hour, as long as it's operational. But that's why we have those other operational tests, we talked about earlier.
And in the winter time, would you also have a 4 to 6 p.m. peak?
That it's much more variable in the winter time, our peak. So that it is much more difficult for me to answer that. Our peak can be as early as 7, 8 in the morning, and it can sometimes be at 9, 10 o'clock at night. It's a lot of different times of the day during the fall and the winter. It's not nearly as predictable as the summer as to when the peak hour will be.
But in general, your system is a summer peaking system?
SPS is, yes, we generally peak. We plan on it being in July every year. We peak most of the time in either July or August. I would say it's in the 80 percentile range that we peak in one of those 2 months.
The summer standby generation charge for the solar option at 99 cents per kilowatt hour per month is 10% of the regular summer demand charge. Does that properly reflect sort of the value that the solar is bringing in terms of offsetting your summer peak?
Well, we think so, or I think so, in particular, but it's part of an overall rate design for production. Okay, that's a little harder to keep track of than the transmission piece for the solar option. So we collect the production cost through the standby generation charge and the on-peak and off-peak energy charge that have the demand cost adders in them to recover production costs. And even in the maintenance, we have a small demand cost adder that's consistent with the off-peak energy charge. And it's that entire rate design is intended to be to where it recovers enough money for a firm customer if that solar facility does not operate. So if it does operate, they get to avoid the costs that are in the energy bucket. So this piece that we're talking about here is some of the costs that they won't avoid, even if they generate fully. And I think this is reasonable because of what we're expecting as the operational characteristics of solar. Once we have some experience, we can all come back and look at it closer. But based on what I saw of the statistics of how this should operate, this seems reasonable in concert with the rest of the rate design for production demand cost.
So is that 10% of the standard demand charge, is that a cost-based calculation?
Well, in and of itself, I would say no. It's why I'm trying. It's part of the overall rate design for the solar. It's not the total rate design for the solar option. It is cost-based. And that's where I've explained in my testimony how the point of the overall charges are to recover production demand costs if the customer, doesn't produce. So, but that's the demand piece that you're referring to is only one of 3 components that have production related demand charges in them. So to say any one component has all the costs would be overstating. I'm not going to tell you that.
So you're saying the on-peak backup energy charge, which is obviously a lot higher than your standard rate energy charge, is designed to sort of work in tandem with that standby generation charge. Is that what you're saying?
Yes, sir. That's what I'm saying exactly. So there's a big chunk of the production demand related costs that are recovered in those time of use energy rates, on peak and off peak energy rates
Right.
through those adders that we've discussed.
I mean, I'll be honest with you, I don't know where the 10% is from in the rules, and it kind of feels like this is a workaround to to deal with that. Would that be a fair characterization?
Well, the 10% comes from Rule 570 that we've talked some about today, not so much you and I, but Rule 570 says that standby generation charges are capped at 10%. And so this is called the standby generation charge for solar, and it's 10%, is what we settled on. So we settled on the cap that Rule 570 allows. That's where 10% comes.
No, I understand that. My point was that I'm not sure where the 10% number in Rule 570 comes from. I'm not sure how it got in Rule 570 in the first place.
Well, yeah, I don't know that part. I apologize. I don't have the history on where that came from.
I realize that. I'm just observing that this seems to be a workaround for that, and I would be curious to know if we didn't have that limitation, and we didn't want to use a volumetric charge in this way, what would the cost-based standby generation charge be for the solar option?
Well, given that we need to put it all together the way we have, you could argue easily enough that this could be zero and you just put all of it in those energy charges, because the important part is already in the transmission part, because we don't avoid the transmission cost. If the generator operates, we should avoid some production costs. So having any of it here or all of it here, is just a judgment call on rate design. And so our rate design construct to try to make sure we give the customer a benefit was we put some of the cost here, but we put some in the time of use rate. You could very easily argue, I personally could argue, you could put 100% of these costs into the time of use rate to try to track the costs and benefits of solar generation.
Okay, but if you look at the costs of your generation, I mean, you've got a lot of fixed costs there, correct? I mean, when you rate base a big wind facility, or when you've got labor costs at your coal plant or your gas plants, those are fixed costs no matter whether they're dispatched or not. Wouldn't you say that it would be more reflective of those fixed costs to have them in the capacity-based charge?
When you're thinking of it as purely designing it for loads, for, hey, this is the load I am serving, sure, I agree with you. That's the whole point behind rate design, for loads only. But now we're talking about a extra complexity on that, where we have a generator and a load, and we're trying to give the generator its proper due, so to speak, of, hey, this generator is bringing benefits to the system. So I think you need to do a mix like this for solar, or you're not giving it its due. And remember, this has the off-peak adder as well for the energy, and the solar isn't on in the nighttime hours, and that's where SPS recovers a good chunk of it's fixed costs that you referred to for our units, because we are supplying them during the nighttime hours, and we design the rate to recover a good chunk of those fixed costs from this customer.
Okay. About the wind example that hearing examiner Hurst was asking you about, you know, if you look at the other generator option, I mean, it seems to me it would be a really bad fit, because, I mean, wouldn't you always be hit with these backup demand charges because you've got a non-dispatchable generator?
Well, it depends on how you size the amount of behind the meter generation relative to your load. Wind net capacity factors as generators have improved dramatically in the last decade. You know, SPSs, for instance, are running at approximately 49–50% capacity factors for a year. So that's daylight and nighttime, right? Those are pretty high. So if you build enough of them relative to your load size, you know, you would end up having excess energy at times, but you wouldn't automatically have to pay backup charges. I don't agree that that would be the result.
Well, I mean, wouldn't you need to set, you know, some level of demand so that you could determine, you know, when the grid is and how much the grid is stepping in to supply? I mean, you know, wind has a great capacity factor if you've got, you know, these big turbines. But sometimes it's operating at 100% and sometimes it's at 0%. I mean, that's just the way it works. And so if you've, you know, nominated a certain, you know, amount, say 50% of your load is, you know, what you've declared that you need, you know, standby service for, you know, the demand charge is going to invariably kick in when your wind generator hits 0. Isn't that correct?
If it hits 0, yes.
And you know, they do. These big wind farms do.
Sure. I just don't agree with the characterization that it happens every day or every month even. It hits 0. And even if it hits it every month, we have the daily prorated thing. So if there's a few days that the wind doesn't blow, you're still paying the same amount as you would have paid under just paying the monthly standby reservation charge. It can work. You have to really study it and size it appropriately, but and maybe we will decide in the future it doesn't work and we'll come up with a third option. But you know, like I was saying earlier, that's always a possibility. There's probably other technologies we could add to this list.
Right. I mean, it's clear this is not a technology neutral proposal. This is a technology centric proposal. I just don't see how the maintenance demand charge, for example, fits with wind, whether, you know, that makes any sense, because you're not going to be taking your whole, you know, wind plant down. You'd be working on one turbine at a time, I would think. So I guess I'm, you know, I would just ask, you know, whether, you know, I guess my impression again is that for dispatchable generators, the other generator option makes sense, but, you know, does it really work for non-dispatchable options?
I still think it can work, and we'll see. I understand you don't, but I don't know how I can respond to that other than to say we think that it can work for everything, and that's how we've designed it. We'll see. If it doesn't
Okay.
work, we'll come up with a new option.
Yeah, I suppose I would need to see the numbers for, a hypothetical wind plant and see how it applies, to be completely convinced that it would apply. But, I guess that's all the questions I can come up with for now. So thank you. I appreciate it, Mr. Berger.
Thanks.
Hearing examiner Hurst, it looks like you're muted if you're talking.
Thank you. Some people feel it's better that way. Since we're at the luncheon hour, I think it might be an appropriate time for us to take our 1 hour lunch, and we'll come back and we'll begin with any examination for Mr. Berger, whether that be a redirect or a cross-examination. We are recessed until 1 o'clock. Thank you. And for anybody still left on, please remember the YouTube is still on, and broadcasting during lunch. Thank you. How you doing, Mr. Lee?
Good, Judge.
Good. Awesome. Well, I think we're at our 1 o'clock. Coming back from lunch. I think we will go ahead. We're back from our lunch and recess. You can go back on the record. And when we ended right before lunch, Mr. Berger, do you remember Commissioner Ellison asking you about a wind hypothetical? And I believe your response was, well, I think I would have to potentially draw that up, or that you could draw that up in a scenario like the ones that you had done before to show how that would work?
I don't recall saying that. I think I recall him saying that he would want us to draw it up for him to be convinced. I don't recall saying I could or would.
Can you? Can you?
Well, I'm not sure what the scenario is. That's what I'm struggling with. Because the scenarios I put in my testimony are simple ones of, is the generator operating or not, and at what capacity? It seems like where we were headed with the questions right before lunch was, well, under this tariff, what won't the wind automatically always pay the firm rate? Does it not work for wind? I don't know how to model that. I wasn't sure where he was headed. I don't know how to model what he was asking.
Can you utilize one of the scenarios that you have already entered into the record as an explanation for how option 2 would work for wind?
I don't know. Again, I don't know where we're headed with it, because those scenarios were meant to be for whatever type of generator. It didn't matter what type it was. If it's running, this is what you pay. So I don't know what I would do differently, I guess.
Okay, so your scenarios don't make any difference if it was wind.
No.
Okay, well, I'll have to wait till the commissioner comes back to try to get some more clarification on that. Thank you.
Okay.
All right, well, we are ready now. We're gonna have our cross-examination or redirect for SPS, if any. Not suggesting there's an obligation, but giving you the opportunity. Ms. Hardy, Mr. Stewart, any questions for Mr. Berger?
Very briefly. Jeffrey Stewart for SPS. Mr. Berger, do you recall a discussion around whether or not standby tariffs were required for state or federal requirements?
Yes.
And are you an attorney, Mr. Berger?
No.
And were the opinions you were giving those of your own or those of SPS?
Those were my opinions. I'm not an attorney. I don't really know the requirements.
Thank you, Mr. Berger. Pass the witness.
Very well. Thank you, Mr. Stewart. Mr. Stoffel, any questions for Mr. Berger?
Yes, thank you.
Go ahead, sir.
Good afternoon, Mr. Berger. Nice to see you again.
Oh,
So I have a few questions for you based on the conversation earlier today with Commissioner Allison and hearing examiners Allen and Hurst. And let's start with where we just picked up after lunch with the questions about the applicability of the rate to wind generation. First, the settlement in case number 20-00238-UT did not specifically require a standby tariff that is appropriate for wind generation, correct?
that's correct.
Are you aware of any large customers interested in installing behind the meter wind generation in New Mexico?
I am not.
In your experience in this proceeding, did any of the parties advocate for a behind the meter wind option as a standby rate?
No, they did not.
Are you aware of any data regarding the expected output of a behind the meter wind generation facility in this proceeding?
None of the testimony I read had any of that data.
And in contrast, you discussed with hearing examiner Hurst that there is interest in behind the meter solar generation, correct?
Yes, sir.
And you described how option one, that rate was designed based on the expected output of a solar facility in New Mexico, right?
Yes, sir.
And specifically, the expected output of a solar facility used to design the option one rate was based on the information in attachment KCH3, which was an attachment to Mr. Higgins' direct testimony in the earlier phase of this proceeding, correct?
I don't recall the exact name of the exhibit, but I believe that is correct.
And that exhibit reflected 30 years of expected solar production using NREL data. Do you agree with that?
I remember it had NREL data on it, yes.
And it was NREL data modeling the expected output for some of SPS's existing solar facilities. Do you recall that?
I don't recall that. I apologize.
That's okay. Now, a few times during the discussion before lunch, you referred to option one of the settlement rate as self-correcting. Do you recall that?
Yes.
And specifically, you referred to the annual tests to establish the contract standby capacity, right?
Yes, sir.
Do you agree that the time of use rate, where all kilowatt hours include a production demand related cost adder, are also part of the self-correcting nature of the option one rate for a solar facility?
Yes, I probably wasn't complete in my description earlier. The time of use rate, the way we have it, keeps everything on track for the current year. And then the measurement that I call the self-correcting mechanism actually then protects things going into next year. So they do work hand in hand.
So even in that first year, if the facility doesn't produce as expected, the customer with the behind the meter generation will be paying more kilowatt hours with the demand cost adder in them, correct?
They will be paying a comparable amount as a firm LGST customer. Yes.
And the discussion you had with Commissioner Ellison regarding how a customer with behind the meter solar would not reduce its demand charges under rate 34. Do you recall that discussion?
Yes.
And Commissioner Ellison also asked you about the ramifications if there was no standby rate. Do you remember that?
Yes.
I'd like to unpack that a little bit. So SPS incurs production demand-related costs to meet its entire system needs, correct?
Yes.
And that system includes 3 jurisdictions: Texas, New Mexico, and wholesale, correct?
That's correct.
And costs are allocated between these 3 jurisdictions based on coincident peak demands, correct?
Yes, sir.
And then within New Mexico, costs are allocated to the customer classes based on their coincident peak demands, correct?
Yes, sir.
But for an individual customer on rate 34, the LGST rate, their demand costs are based on their peak demand whenever it occurs, regardless of whether it's on peak, right?
That's correct.
So if a customer installed behind the meter solar and it produced as expected, consistent with the data in attachment KCH3, that would reduce SPS's load, which would in turn reduce the production resources required to meet system peak demand, right?
If it operated as expected during the summer peak months, that should be the case, yes.
And under that same assumption, it would also reduce New Mexico's peak loads, reducing the costs allocated to New Mexico, correct?
Yes.
And it would reduce the LGST class's load, which would reduce the costs allocated to that class, correct?
It should. Of course, there's also the average, and it's an average and excess. So without getting it deep into the details of the hypothetical, it should, but as far as I can go.
To the extent those costs are allocated on a demand basis, if it lowered the class's demand, it would lower the costs allocated on demand, right?
It would lower the CP portion of the AED for CP allocator. Yeah. So.
But for a customer who installed the behind the meter generation, it would not reduce their production demand related costs, even if their individual peak demand occurred outside of the system peak, correct?
The way that rate 34 works, that's correct, because it's billed on a non-coincident basis, yes.
So in other words, the benefits that the behind the meter generation provided to the system, to the state, and to the LGST class would not flow to the customer who installed the behind the meter generation, correct?
That's correct.
During settlement discussions, and we'll keep this at a high level, parties generally raised concerns regarding the potential for a customer with behind the meter solar being subsidized by the other members of its class. Do you recall that?
Yes.
Is it your understanding that the settlement rate design addressed those concerns?
Yes, it is.
Thank you. A couple other brief questions. Do you recall the discussion with Commissioner Ellison regarding SPS's old standby rate?
Yes.
And you discussed the limit on the number of hours that could be used under that rate before the customer would be kicked over to the standard rate applicable to their size, correct?
Yes, sir.
That limit was specific to on-peak hours, correct?
That's my recollection.
And do you recall the discussion with Commissioner Ellison regarding the recovery of production-related demand costs through energy charges?
Yes.
SPS currently recovers production-related costs through energy charges for other customer classes, right?
That's correct.
And that includes at least one class that has demand metering capability, right?
Not sure exactly what you're referring to there. I apologize.
That's okay. Do you recall the discussion with Commissioner Ellison regarding the company's investment in production resources being long-term?
Yes.
And you noted that the company is facing a near-term shortfall of capacity, right?
Near term being within 3 to 5 years. So depending on your definition of near term. Yeah.
And the company is also experiencing load growth, correct?
Yes.
Do you agree that SPS's industrial customers potentially helping to support any system or regional capacity shortfall by investing their own resources into behind the meter generation is likely a good thing for the New Mexico customer and something to be encouraged?
Well, if we're able to work together in the planning and know when it would come online relative to SPS planning to add other resources, it could very well be beneficial to everybody, yes.
Thank you, Mr. Berger. No further questions.
Thank you, Mr. Stoffel. Any questions? Mr. Jernigan?
No questions, ma'am. Thank you.
Thank you. Ms. Drake, any questions?
Not at this time. Thank you, ma'am.
Thank you. Mr. McMillan,
Yes, briefly, Your Honor.
go ahead, sir.
Good afternoon, Mr. Berger. Do you recall Commissioner Ellison asking you whether a 10% standby reservation charge for the option 2 customers is cost-based?
Yes.
And when you were asked those questions, you responded that it's your position that the 10% charge is below the transmission costs that SPS incurs to provide that standby service, right?
Yes.
Now, is it fair to say that your position is that SPS incurs the same amount of transmission cost to serve a customer that takes standby service 1 day out of the month as it would if that was a non-standby customer who took service 30 days? Is that a fair characterization of your position?
Not sure I followed that exactly, but my position is the way we have to pay for transmission service is we take the metered load and we add to it the behind the meter generation to pay for transmission. So we don't, but it's billed at the peak hour. So we look at the peak hour each month and what the load was, add to it the generation, and that's what we pay for transmission for our loads. So my position is we don't avoid any transmission costs.
But it is true to say that a standby customer who is not actually taking backup service from SPS, they're not using transmission at that time, right?
If you're talking about a customer whose load perfectly matches their generator, sure, at that particular hour, they are not using the transmission system, yes.
And to the extent that a standby customer does not take backup service at the time of the SPS system peak, they don't contribute to peak load on SPS's transmission system, correct?
Well, that's not correct, given what I just explained as to how peak load is calculated under the SPPO. We have to include all load for those peak load calculations that we send to SPP. So you still contribute to that peak load calculation.
Okay, so Mr. Berger, would you agree that there is perhaps a philosophical difference between SPS and the other parties about the necessity of including behind the meter load when reporting to the SPP?
Some other parties, there's probably a philosophical difference, which is what I tried to note in my testimony, that we think the 10% is low and other parties think 10% is high, right? If we didn't have a philosophical difference, there wouldn't be a range of opinions.
And you would agree, and in fact, all the parties agree that for the purposes of this stipulation, that 10% is a reasonable number to put into this rate, right?
I do, and that's what I tried to get at in my testimony. Is that we're both views of it, and the 10% is reasonable to get a settlement in this case and to accommodate Rule 570.
Okay, and it's fair to say that once this rate is in place and businesses start using this rate, then we'll have more actual data to base a rate on later, right?
That's my expectation, and what I talked about, I think, some with Mr. Ellison earlier, Commissioner Ellison earlier, is that, yeah, once we have more experience, we could add more options if we need to. We could modify the options we currently have. You know, that's how this tariff will likely evolve over time.
But where we are right now, feel that that's a good starting point.
Yes.
Thank you, Mr. Berger. Nothing further, Your Honor.
Thank you, Mr. McMillan. Mr. Marks, questions from you?
Just a few.
All right, sir.
First one, Mr. Berger, the term load factor came up in your examination this morning. I think the record might be good if you could give a definition for that.
Okay. I was using load factor as an annual type base. So a load factor is a measurement of the amount of energy a customer does consume relative to the maximum they could have consumed. So you calculate that. Your denominator is your peak demand times, in a normal year, 8,760, and your numerator is the actual energy the customer consumed, and that's the load factor.
Right. So it's essentially mathematically the average demand divided by the peak demand.
That's correct, yes.
Okay. And so a customer that had a load factor of 1 has the same demand 24/7, 365.
Yes.
Okay. And I think the example you used was load factors of 90%. You could get there by having half the hours at peak and half the hours at 80% of peak, correct?
That's correct.
Okay. And when Commissioner Ellison was asking you, he used the term capacity factor in some of his questions, but I think you assumed he meant load factor when you're giving your answers. Is that correct?
Possibly, I may have missed that. So I can't say yes because I don't remember that.
Do you recall him using the term capacity factor in his questions to you?
No, I apologize. I must be too nervous today.
Yeah, okay. Okay. Let's see. You testified this morning that a customer who was going to take this standby service tariff would still pay the fuel clause for any energy that they consumed. Do you recall?
Yes.
And then that's accurate, correct?
Yes, there's a fuel cost adjustment section in the tariff.
Okay, and they'll pay the same fuel clause rate that a customer who's not on the standby tariff in the same class would pay.
Yes, that's correct.
And would you agree with me that when in order to deliver energy during peak periods generally costs more than in off-peak periods? I'll just end there.
All else being equal, yes, that's normally the case. It doesn't always work out that way.
Okay, and it's normally the case that the cost of purchase power, if you have to go to the market, is higher during the peak, correct?
That's the trend in the SPP integrated marketplace, that the prices during the on-peak hours are higher than the prices in the off-peak hours.
And it's also the case that even using SPS's own resources with economic dispatch, the least efficient resources are more likely to be used on peak than off peak, correct?
I'm not sure that I can go there because of the way you characterize that. You know, it depends on. It's not as simple as that, but because it depends on what units are available, what the fuel prices are. So without more assumptions, I can't just say, yes, that's true.
Right. Isn't it the case that SPS tries to operate its system to minimize the fuel cost to its customers?
Yes, we do.
And you'll use the more efficient units based on fuel cost and heat rates whenever possible, right?
Yes, and we offer all of our units into the SPP market so that if someone else wants the output and buys it, we can credit that to the fuel cost as well.
Okay, but in an off-peak period in the middle of the night, you're going to be using a low fuel cost unit, correct?
All else being equal, yeah.
And in the middle and at 5 p.m. in the afternoon in July, you're more likely to have to use units that are more expensive.
Again, all else being equal, yes, but there are minimum run times on generators. There are other assumptions that don't make that 100% correct.
Yes, of course. And we're not having a case to get into that detail. But I think you agreed with me that all things being equal, fuel and purchase power is more expensive during those system peak hours in the afternoons than it is during off peak. Correct?
Yes.
Okay. And to the extent that a customer that installs solar generation and takes advantage of this tariff, do you expect that will have a positive contribution to the fuel clause in terms of lowering the average cost per kilowatt hour there?
I haven't studied that. So I couldn't say.
If I mean, you agreed with me that on peak, the hours that correspond to when solar is generating tend to be a little bit more expensive to the fuel clause.
Again, we're trying to do a bunch of assumptions to reach a general conclusion that I just can't get that far. We're making way too many assumptions to get to a conclusion. I haven't studied it. I can't just assume my way to that answer.
Okay. I'll let it go. You mentioned you knew of one QF in New Mexico, and I think it was a wind QF. Were you referring to the generator that's affiliated with Mesalands Community College?
That's the one I was referring to, yes.
Okay. And do you know anything about that particular installation, why it was constructed?
I know a tiny bit about it. My recollection is it was constructed mainly because they put a college there to teach people how to maintain wind turbines, and they wanted a wind turbine there to use to help them teach. But that's as deep as I know on it.
Hey, thank you. I think that's the answer I was looking for. Are you aware of anywhere in New Mexico, Texas, or actually anywhere where a customer has installed a wind turbine in that, you know, in the last 10 years for economic reasons behind the meter?
I think, I don't know the situation. Pantex has built some wind. I don't know exactly the context as to why they did it, and they're in Texas. I don't know exactly when and why they built some wind.
Okay. And conversely, are you aware of customers in New Mexico and Texas that have installed behind the meter solar for economic reasons?
Well, the rooftop solar, I think, has been for economic reasons because there were incentives for all of that. So I would say, yeah.
And are there still incentives for solar?
I'm not aware of the status of all of those tariffs where we gave the incentives and purchased the RECs. I'd have to research that.
Okay. In terms of for new systems?
Exactly.
Okay. I don't think I can. Nothing further.
Thank you, Mr. Marks. Mr. Bagatko, anything from you?
Madam Hearing Examiner, nothing for Mr. Berger, but we thank him for his attendance today.
Thank you, Mr. Bagatko. Subject to clarification regarding a potential bench request on when you are excused.
Okay, thank you.
Well, actually, I did have one question more for you, Mr. Berger.
Okay.
Of all the types of generation that potentially might utilize these two options, is it really going to be cost effective for one of your large generation transmission customers to make this kind of investment rather than pay SPS for their service?
I don't know. That's a tough one because depending on the fuel source, if you're doing thermal, if you are a company that you own the fuel source, that could be basically free fuel. That adds a lot to the economics in a hurry for behind the meter generation. And then for other types, mostly the renewables will largely depend on if you're wanting to do it purely for economics, it would boil down to the incentives, because currently I don't believe they are economic without incentives.
So then you think that you have some current large customers at the transmission level that own their own fuel source?
Well, they could. I don't know if they do. Again, it's customer by customer, but we have a lot of oil customers, and when you drill for oil, you tend to find a lot of natural gas, and you could use it to power a generator as opposed to selling the natural gas. So they could look at the opportunity cost of selling it in the market or using it to generate their power. So that's one of the trade-offs they would look at.
What would it cost even to build a small natural gas generating plant?
I haven't researched that. I apologize. I don't have any statistics on that.
Do you think it would cost millions of dollars?
I would expect it would, but I don't know.
Okay. Okay, I'm just wondering about if you build it, they will come theory, since it's baseball season. If this tariff is actually going to incentivize, or if it's just going to prepare the way for that special customer that you're talking about, or not. So anyway, I thank you, sir. And again, you are excused pending, unless someone had a question on my question. No. You're excused pending the clarification regarding the bench request. Mr. Stewart, Ms. Hardy, anything further from SPS?
Nothing further from SPS.
Very well. I believe then that we will go to our next witness, and Mr. Stoppel, Mr. Rusha.
Yes,
I see Mr. Higgins in the waiting area.
that's our guy.
Let's admit him. And hello there, Mr. Higgins.
Hello, Madam Hearing Officer. I'm just hearing examiner. Sorry, I was just jumping from the YouTube over to our call here.
Excellent. And while you're doing that, Mr. Higgins, did you just go into YouTube, or did you get that from the commission's website?
I went through a link that my attorney forwarded to me to YouTube directly.
Okay. Very well. Mr. Lee, would you please, well, I guess you should introduce your witness first, then we'll swear him in.
Sounds good. The NMLCG calls Mr. Kevin Higgins.
Very well. Mr. Lee, would you please swear in Mr. Higgins?
Mr. Higgins, would you please raise your right hand? You solemnly swear the testimony you're about to give the matter and opinion should be the truth, the whole truth, nothing but the truth?
Yes, I do.
Thank you, sir.
Thank you, Mr. Lee. Go ahead, Mr. Stoffel.
Good afternoon, Mr. Higgins. Will you please state and spell your name for the record?
My name is Kevin C. Higgins, Kevin, middle initial C, Higgins.
By whom are you employed and in what capacity?
I'm a principal in the consulting firm Energy Strategies.
Did you prepare testimony in support of the uncontested comprehensive stipulation on behalf of the NMLCG in this proceeding?
Yes, I do.
You did not have any attachments to that testimony, correct?
Correct.
And your testimony has been marked as NMLCG Stipulation Exhibit 1. Do you have any corrections or clarifications to your testimony in support of the uncontested comprehensive stipulation?
Yes, I have one word that I need to correct. On page 9, line 4 of my testimony, I referred to an attachment that I had provided earlier in this case. And I referred to it as Exhibit KCH3 when I should have referred to it as Attachment KCH3. So that is my one clarification.
And with that clarification, if I were to ask you the questions in your testimony in support of the uncontested comprehensive stipulation here today, would your answers be the same?
Yes.
Thank you. I move for the admission of NMLCG Stipulation Exhibit 1, the testimony of Kevin Higgins in support of the uncontested comprehensive stipulation.
Mr. Higgins, are the answers true and correct to the best of your knowledge?
Yes, they are.
And if you were asked the same questions today as were in your direct testimony, would your answers be the same?
Yes.
Very well. Any objection to what's been identified as NMLCG 1 in support of the stipulation, Mr. Higgins' direct testimony, with the one clarification on page 9. Hearing no objection, NMLCG 1 is admitted. Mr. Stoffel?
Thank you very much. Mr. Higgins is available for questioning.
Very well. rather than going individually, are there any cross-examination questions at this point based upon Mr. Higgins' testimony? Hearing none, I've got a few questions, and the hearing examiner, Ellen, may have a few questions also for you, Mr. Higgins. Welcome back.
Thank you.
It hasn't been too long.
No.
Since you were just here, and are you happier with the proposed solution?
I'm very satisfied with the proposed solution. I believe the solution that's been provided is comprehensive and has taken into account the positions of the parties that provided testimony in this proceeding and represents a good faith effort on the part of all the parties to achieve a good resolution that is in the public interest and provides standby rates that are just and reasonable.
Any idea why I didn't have this 9 months ago?
Well, I don't want to speculate about that. To be candid, Madam Hearing Examiner, I do believe that your recommended decision did focus the attention of the parties to try to reach a resolution. And I want to especially commend the efforts of Mr. Berger, who put in a lot of time and effort into working with the parties to try to reach this resolution.
Sir, if we can look at page 3 of your testimony, and just generally you're describing what option was at lines 10 and 11 on page 3. And is the size, why is there a size floor in the option?
Well, the size floor is there, in my view, for two reasons. One is that it's the size floor that I recommended in my testimony when I was proposing a solar specific rate. And I recommended that for both in the last general rate case as well as in this case. And the reason I recommended that size floor is that the SPS tariff currently has various products that provide or allow for a customer to acquire renewable generation. And all of those products are for customers seeking renewable generation that are below 2 megawatts. And in attempting to argue for and advocate for the implementation of a standby tariff, I wanted to be sure not to complicate what I was proposing with any other products that might be available on the SPS tariff. And so by focusing on 2 megawatts and above, and clearly focusing on customers, a customer class that generally consumes large amounts of power, that this 2 megawatts seemed to be a clean line of demarcation to make it clear that we were not, that I was not attempting to provide a venue that overlapped with any other service offering on the SPS tariff.
And with that in mind, sir, is there a particular, and I know it's going to depend on the size of the large customer, but just generally, I mean, is 2 megawatt solar facility going to provide sufficient energy to be able to carry the load during peak periods for such a large generation customer
Well, 2
or large
megawatts,
transmission customer.
sorry, 2 megawatts is the minimum size. Customers could certainly put in solar facilities that are greater than the size under this standby tariff. And so it would be up to each individual customer who was looking to make this kind of investment to evaluate the size of facility that would be most suitable for them.
Do you have any idea what it would cost to put in a 2 megawatt system in New Mexico?
I don't have a number off the top of my head to be quite candid, but you know, it'd be a significant investment even for 2 megawatts.
Over $1 million?
Could be. I hesitate to, you know, to sort of speculate off the top of my head about that, but it would be a significant investment.
Okay, I'm just, again, I'm just trying to figure out in my head, as you probably just heard when the last witness, what type of, you know, what's the potential that people are going to take under this tariff, and what type of customer would that be? Because it just seems like if it's going to cost $25 or $30 million to put in a self-generating facility of whatever type, that would be a huge investment for even a large customer to take. And I'm just wondering if some of the solar options that were capable of actually defraying the energy cost, what that might be.
Well, the reason that I made the proposals that I made in the rate case and in this proceeding in the first place is because there are customers who were large customers on rate 34 who are interested in investing in behind the meter solar. And to a certain extent, that lines up with objectives they may have at the corporate level about reducing their carbon footprint, or at least offsetting part of their carbon footprint. And it becomes an important question as to whether or not the utilities tariff can reasonably accommodate that type of behind the meter investment and provide reasonable terms for a customer that makes that kind of investment. So the idea isn't to provide a discount to such customers, because this rate does not provide a discount. The idea is to provide service under reasonable terms, given the investments that customers might make in reliance on this type of standby. So, and I believe that the rate that's been negotiated by the parties and provided here would accomplish that objective. I think it would strike that balance where customers who made this investment would still have to pay significant charges, but they would be reasonable charges and would reasonably reflect the capacity that the customers would be bringing to the system with their own investments.
And is it also your understanding, Mr. Higgins, that or understanding and belief that the reasonable terms that are provided in option 1 are not going to result in a customer taking under option 1 being subsidized by any other SPS customer?
I'm quite convinced of that. In fact, you know, quite frankly, if the chances would be greater that a customer taking service under this rate, under option 1, would in fact be subsidizing the rest of the system rather than receiving a subsidy themselves. As the,
how so?
In the sense that the customers under this rate, for example, would be making a significant contribution to demand-related costs, by my calculation, about 47.5% of the generation related demand costs. At the same time, they would be on average displacing about 70% of the on-peak capacity requirements that SPS has. And so they would be paying in relationship more demand-related costs than the capacity that they would be requiring on peak. Yet let me say, I believe that's still a reasonable trade in this particular situation. That I think that I would, quite frankly, think it's reasonable when initiating a rate like this to err on the side of being conservative and to ensure that customers taking service under this rate are not subsidized. And so I believe that we struck a good balance here by ensuring that we've got a conservative arrangement where the customers are making a very substantial contribution to the recovery of demand-related costs.
And just so I get your opinion, sir. My understanding is that option 1 is for solar only, and option 2 would be available for any other type of generation. Is that your understanding?
Yes.
Do you believe it's possible to utilize renewable resources under option 2?
I believe that depending on the type of facility that it is, they could certainly, for example, a biomass facility would be able to take service under option 2 because its profile would look quite a bit like a thermal facility. Theoretically, a geothermal facility could do that as well. So I do think that option 2 would be able to provide standby service under reasonable rates for those types of renewable facilities.
What about wind?
Well, as Mr. Berger testified, I think wind is probably a bit more challenging. And let's also be candid here. I'm not aware of any large customers who are seeking to put in behind the meter wind facilities and are in search of a standby rate. But having said that, I do believe that a customer could take service under option 2 with the wind facility. Whether the economics would work out for such a customer or not, I don't know at this juncture, and whether it would warrant further refinement or an additional option if there's interest would be an open question. So I would agree with Mr. Berger's assessment of the situation, which is that we were not addressing a compelling interest at this time to provide a standby rate for customers who want to put in wind. The option 2 is available for them. And if it turns out that that is not a good fit for wind, then perhaps another type of option could be developed if there is interest in that type of possibility.
But you also understand that perhaps the commission might have broader considerations other than what a party is requesting in any particular case, Mr. Higgins?
Certainly, I appreciate that.
And that I need to have an answer should the commission ask me, is this a technology neutral proposed tariff?
Well, I do believe that the option 2 is technology neutral in the sense that it would provide service under non-discriminatory terms. But I do also acknowledge that wind would have some unusual, well, would have some special characteristics. So let me put it this way. Option 2 doesn't work for solar because it would subject solar customer to the same type of demand charge they would otherwise pay under the ordinary rate 34, which is why, we designed a rate that recovered demand related costs through the time of use charge. But solar has the advantage of having a predictable generation shape that strongly coincides with SPS's peak period. And so from a practical standpoint, it provides us with a good opportunity to use a different rate design tool, namely time of use rates, to achieve a reasonable and predictable outcome for solar. For wind, there would be greater challenges in terms of designing something that was more predictable. So that's where, greater effort to design a wind-specific option would maybe be necessary if customers want to pursue behind the meter wind and find that option 2 wasn't working. But it could very well be the case that option 2 would work for them. I haven't specifically tried to address that.
Sir, if we could let your testimony on page 6. And you're answering the question posed at lines 1 through 6. How does the structure of the standby rates and the stipulation compare to the rates you recommended in your direct testimony? And I have a question about line 14 through 17. The on-peak period continues to be the hours of 12 p.m. to 6 p.m. during the months of June through September, but it is expanded from Monday through Friday to 7 days a week, excluding the 4th of July and Labor Day. What was the impact of going from 5 days to 7 days?
Well, that increases the amount of on-peak hours by about 40%, right? So if you've got 5 on-peak days a week and you increase it by 2, you've got 40% more on-peak hours. And so you've expanded the amount of time that customers on this rate would be subject to the higher on-peak charge. At the same time, as part of this settlement, the on-peak rate was reduced from what I had recommended. I had recommended an even higher rate than the parties ultimately negotiated. So you had sort of numbers moving in opposite directions, you might say. You have a lower on-peak charge than I recommended, but you've got 40% more on-peak hours.
So you agreed to this potentially because you didn't think that the customers would actually be taking during the on-peak hours?
No, they will be taking during on-peak hours. They, on average, solar customers would be getting about 30% of their nameplate facility output from SPS during the on-peak hours, because one doesn't expect solar to be running at 100% for the entire on-peak period. And so they certainly will be making a contribution. But as I mentioned, the rate that the parties negotiated. It is also the time of use, the on-peak time of use rate for backup service was reduced from what I had recommended. And so it was a matter of different trade-offs being considered. And I'll add that this rate design also includes an off-peak demand-related charge that I did not propose in my original proposal. So the net effect is that this proposal that the parties have agreed to will cost a behind-the-meter solar customer more money than the initial proposal that I had made. But this is part of the art of compromise and parties being reasonable. And I still believe that this does produce reasonable results.
Okay. Sir, did any of your analysis or your consideration of your objectives include any type of generation other than solar alone?
The focus of my analysis and testimony has been on solar. Having said that, as being part of the litigation phase of this case, I did review the company's initial proposal for rate 85, and I did review the criticisms that other parties have made about that rate 85 regarding its appropriateness for other types of behind-the-meter generation, such as cogeneration, and I agreed with the other parties that addressed the issue that converting rate 85 as proposed by the company into a rate that had a daily demand charge made sense. And so, whereas I haven't conducted detailed analysis of the economics for a cogeneration facility with this rate, I do agree that the design of option 2 that has been adopted is a good design. It follows, in my view, best practices that I've seen elsewhere in the country for having a standby rate for behind the meter thermal generation or other types of renewable generation that perform similar to thermal generation.
And what is the distinction between behind the meter generation and cogeneration?
Cogeneration is simply a type of behind the meter generation, or can be a type of behind the meter generation. It's simply a behind the meter generation that uses often a fossil source, but also uses the thermal energy in an economically efficient manner, so that it qualifies for being a cogeneration facility. But it is simply a type of behind the meter generation.
So it's energy and heat.
Yes.
And all I was trying with my prior question is to figure out whether or not in your consideration of a potential solar generator, whether you were including any options that had battery storage.
Thank you for that clarification. I did not specifically look at battery storage as an option here. So that, I guess that should answer your question.
Let's look at page 8 of your testimony, sir, and you're still answering the question from page 7, line 11. Is option 1 a cost-based rate? And on page 8, lines 1 through 5, you say importantly, the trio of option 1 charges is designed to provide the same annual revenue to SPS from an option 1 customer operating without its solar facility as would have been recovered from the customer under rate 34, including the generation portion of the rate 34 demand charge. Why is that important?
Well, that's important because it demonstrates the nexus between the rates that are being proposed here for standby service and the current rate 34 that the commission has approved as a just and reasonable rate. That is that the rates that have been proposed are in essence derived directly from rate 34. And an important litmus test of the reasonableness of the rate, as explained by Mr. Berger as well in his testimony today, is that one can ask the question, well, what would happen under this standby rate if the facility didn't operate? What would the customer wind up paying under those circumstances? And these rates were designed to ensure that a customer taking service under this rate would pay the same charges as they would otherwise pay to rate 34 if their facility wasn't operating. And so it demonstrates that this rate is derived directly from the costs to serve rate 34.
Thank you, sir. Hearing examiner Allen, do you have questions for Mr. Higgins?
Just briefly, Mr. Higgins, my understanding is that the rate you are saying here was designed so that SPS's income or revenue is the same regardless of whether or not there's a behind the meter customer utilizing the standby rate as if they weren't using the standby rate?
To be clear, what I was saying is that if a customer on this rate had a facility that was not operating, then the rates they would pay under the standby rate would recover the same revenue that the customer would otherwise pay on rate 34 without a solar facility operating.
But if their facility is operating, there's a financial benefit to the customer to utilizing the standby rate.
Correct. They would pay less than what would otherwise be the full demand charges of rate 34. But they would still make a significant contribution to those demand charges through both the 10% standby generation charge as well as the time of use backup energy charges that have demand components to them.
And do you consider, you indicate on page 7 that this is the revised option 1 is a cost-based rate? Correct. And
yes.
So, sorry, go ahead.
No, I was agreeing. Yes, it is a cost-based rate.
Okay. And when you say it is a cost-based rate, it's not based on, is it based on actual costs or what costs are being utilized to make that determination?
Well, I believe it is based on the actual costs. Let's start at the top. They will pay, a customer under option 1 would pay the same exact transmission charge as a rate 34 customer that is not taking this, that is not on the standby rate. With respect to the generation related charges, as I indicated, if the customer was If a customer's facility was not operating, then the rates would recover the same revenue that rate 34 would recover through the demand charge. If the customer's facility is operating as expected, then we would expect, and you can see this if you look at attachment case CH3 that was filed with my testimony earlier in this case, that during the on-peak period, the customer with a solar facility would be expected to allow or to provide capacity equivalent to about 70% of its nameplate generation during on-peak hours on average during the 4 summer months and during the on-peak hours of 12 to 6 p.m. And by having a rate or by having a service, providing a service that would allow or would provide for a capacity contribution equal to about 70% of their nameplate on average. Having some recognition of that capacity contribution in the rate design, which this rate does, makes it a cost-based rate in the sense that it acknowledges that customers on this rate would on average be bringing capacity with them. And the demand charge type of rate design would not allow any kind of recognition of that capacity that these customers would bring. So, and I believe this, viewed as a whole, it's a cost-based rate. If anything, as I said earlier, it errs on the side of potentially over-recovering demand-related costs from these customers, because they will be making, I expect, will be making a large contribution to being able to avoid capacity. But in the interest of not allowing the perfect to be the enemy of the good, it's a reasonable starting point.
And then are those arguments equally true for option 2? With respect to it, whether or not it's cost-based?
In my view, option 2 is a cost-based rate because it, again, derives directly from rate 34. It is based on the same demand charges that rate 34 customers pay. It uses the Rule 570 provision that establishes that a reservation charge up to 10% could be applied for that option. And very, very importantly, it provides for a daily demand charge, which is a proration of the demand charge that would otherwise apply for an entire month if a customer on option 2 should have to use SPS's facilities or output to take standby service, or backup service. So I do believe that it is a cost-based rate.
Thank you, Mr. Higgins.
Thank you.
Okay. Mr. Stoffel, any redirect of your witness?
Yes, very briefly.
Go ahead, sir.
So, Mr. Higgins, keying off the conversation you were just having with hearing examiner Allen, on the solar rate option 1, much of the discussion has been kind of balancing the recovery of capacity costs from a customer with behind the meter solar with the capacity benefit in the form of a load reduction that behind the meter generation brings to the system. Do you agree?
Yes.
And you're familiar with how SPS allocates the cost of its wind production facilities, correct?
Yes.
And does SPS assign any capacity value to its wind when it proposes to allocate those costs in its rate case?
No.
Thank you. No further questions.
Thank you, Mr. Stoppel. Any cross-examination questions based upon hearing examiner Allen's questions or my question? Hearing none. Mr. Higgins, thank you very much, sir. You are excused.
Thank you very much.
Mr. Stoppel, anything further from New Mexico Large Customer Group?
Nothing further from the NMLCG. Thank you.
Thank you. Very well. I believe our next witness is from FEA LES, and who'll be offering that witness. Ms. Drake?
Yes, ma'am, but as we informed you, Mr. Gorman is
Oh, that's right.
unexpectedly not available today. He's at a funeral. So we were wondering if we could have him appear tomorrow, if there are still questions for him.
Yes, there are questions for Mr. Gorman, and will he be available at 9 o'clock tomorrow morning?
I believe so. Mr. Jernigan, I believe that's our understanding from Mr. Gorman. Is that correct?
To the best of our knowledge, yes, ma'am. We've not been able to contact him today for obvious reasons, but
Yes.
he did say, explain that on Friday that he should be available tomorrow.
Very well. I have a few questions, and I believe that Commissioner Ellison has questions for Mr. Gorman. So thank you. So
you.
we will put off hearing from Mr. Gorman and go to the next witness, which will be the Occidental witness, Mr. McMillan.
Good afternoon, Your Honor. Mr. Pollock is in the lobby, or so he says.
There you are, Mr. Pollock. Good afternoon.
How are you?
I am okay. How about yourself?
Wonderful.
It's the day before tax day.
Already done.
Yes, you and me both.
Thankfully. Another
Let
great
that-
year for the government.
Let that checkbook do the walking. Yes, bless you, whoever just sneezed. Bless you
you.
again. Would you like to go ahead
I'm
and?
put it on mute.
Oh, okay, good. Mr. McMillan, would you like to go ahead and introduce your witness?
Yes, Your Honor. Well, I'll let him do it himself. Mr. Pollock, could you introduce yourself, please?
Hi, I'm Jeffrey Pollock, and I am testifying on behalf of Occidental Permian Limited.
Very well. Mr. Lee, would you please swear Mr. Pollock in?
Mr. Pollock, you solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir.
Okay. Go ahead, Mr. McMillan.
Mr. Pollock, do you have a copy of what's been marked OPL Stipulation Exhibit 1?
Yes.
What is that document?
That is the testimony I filed in support of the stipulation, consisting of 10 pages.
Was that document made by you or under your direct supervision?
Yes.
Do you have any corrections to that document other than the limited errata that we filed on Friday?
No.
And if you were asked the same questions that are written in that testimony here today, would your answers be the same?
Yes.
And are your answers in that testimony true and correct to the best of your knowledge?
Yes.
Your Honor, I offer OPL Stipulation Exhibit 1.
And Mr. Pollock, I'm the one that pointed out at the pre-hearing. Page 7, line 16. And you corrected that, sir, correct?
Yes.
And Mr. McMillan, the correct version of the testimony was in fact filed in the Dropbox, correct?
My understanding is yes.
Very well. Any objection to what's been identified as Occidental's Exhibit 1 in support of the stipulation, Mr. Pollock's direct testimony? As affirmed by him here today. Answers are true and correct, Mr. Pollock.
Yes, they are.
And if you were asked the same questions today, you would answer the same way.
I would.
Absolutely. Any attachments to your testimony?
No,
Why not?
didn't need them. I put them
No.
in tables.
Yeah, okay, all right. Didn't need to add them at
It's
the
all,
end.
it's all in one container. You don't have
It's
to
a-
look elsewhere.
It's kind of like footnotes. If it's important enough to be said, put it in the body, eh?
Yes.
Okay. Hearing no objection, Occidental Exhibit 1 is admitted. Mr. McMillan?
Your Honor, we present Mr. Pollock for examination.
All right. Any cross-examination questions by any party to Mr. Pollock's testimony? No. I've got a few questions for you, sir. And I guess I'll ask you the same question that I've been asking the other witnesses. Why didn't we see this 9 months ago?
I don't have a better answer than Mr. Higgins. You know, hindsight is always 2020. That's
Boy, have I heard that all my life. Okay,
yeah, hindsight in
you're-
2 years ago.
but you're pretty satisfied with the result as compared to where you were 6-8 weeks ago?
I think overall it's a good product. It is a settlement. Nobody ever gets everything that they want, and we certainly didn't get everything we wanted, but I think it's a good foundation. It's a good building block to build out a rate that will address other classes that have similar needs in the future. And you know, just like episode 1 of Star Wars, you have to start somewhere to begin the saga.
But the customer, if I recall the testimony correctly, Mr. Pollock, the large customers whose interests that you represent don't have any thoughts at this point about investing in self-generation, do you?
I think they have lots of thoughts. I don't know to what level those thoughts have come to fruition. I'm not really privy to that decision making, but clearly there are, and you read the trade press as I do pretty often, and you can see Occidental's been in the news quite a bit about, you know, carbon removal and things like that. And so who knows? I mean, it just creates an opportunity for some economic projects to go into effect that will benefit customers, broadly speaking.
So then, I guess, is it fair to say then, I mean, I thought that Occidental and FEA LES, I thought that these large customers' primary interest in this case was making sure that they didn't subsidize solar self-generators. Was my thinking wrong on that?
No, I think that the idea was, we needed a standby rate, as you've harped before in, you know, previous questions, and SPS was sorely lacking a standby rate. And 2, you know, we wanted a standby rate that's cost-based. As, you know, Mr. Higgins and others have testified, this is a derivative of rate 34. It's a very dynamically priced rate, which makes it more complicated than the average rate. but also it makes it more adaptable to differing circumstances. And so that's really what we're looking for, something that was cost-based and dynamic to address multiple scenarios and situations, and therefore it would not create or result in any kind of cross subsidies.
And define for the record what you mean by dynamic rate.
Dynamic in the sense that the rate will track costs based on different levels of usage. So backup power usage characteristics are very different depending on type of resource, in terms of timing, in terms of, frequency and duration. The more you use service, the more you pay. That's what the rate does. I mean, the more backup service you take, the more the rate looks like rate 34. That's by design. Similarly, the maintenance rate looks more like a lesser quality of service, but the more days of maintenance you take, the more you pay. You get a better rate because it's done off peak, and it has to SPS has to have sufficient capacity. And so in that sense, in all senses, the rate is dynamic, and you've got the two options too that apply to different situations.
And as part of the negotiation and the trade-off back and forth, it wasn't just the large customers potentially interested in investing in behind the meter solar, which, as you point out, that may be your large customer now. But
Right.
Again, trying to look back at the beginning of the case, it seems as if the interest might have been more with somebody like New Mexico Large Customer Group, who Mr. Higgins just said, that's what I looked at. That's who I'm representing, the people that I'm representing, that's what they're interested in. So, but they weren't the only beneficiaries in this stipulation, were they?
Well, I think broadly speaking, any customer, the large customer that's looking at these opportunities or might consider these opportunities now has, I think, another chip that they can look at to say, hey, now maybe a project is more economical because now we've got this other rate in place that we can use to take advantage of the economics and still pay our cost-based share of the system that stands ready to support us when we need them.
And I guess I should specifically direct you to, traditional non-renewable, no, that's not what I want to say. Large transmission customers on SPS's service also benefit from the stipulation, don't they?
Well, in the sense that this rate goes into effect, there won't be any cross subsidy between them, between rate 34 customers and their counterparts on this other rate. So to that extent, it's a benefit. And like I said before, to the extent that it creates some opportunities for some economical projects, that's a benefit to be realized over time.
But didn't the non-generation customer, didn't they also get potential I keep saying non, but I mean the non-solar, the option 2 customers, didn't they get some potential benefits in terms of the some of the definitional changes and time period changes that weren't initially offered by SPS?
Certainly they benefit from the structure of the rate itself, because otherwise, if you had a forced outage, you end up paying a full demand charge, which is not cost-based at all. So I think to the extent that the rate was structured, option 2 specifically with daily demand charges on both the backup and maintenance rates, made it much more cost-based for option 2. And that's
Well-
part of the dynamic, nature of the rate, because if you take backup service for one day of the month, you're not imposing the same level of cost on the system, either generation or transmission, as somebody taking service for 2 weeks or the entire month.
And I guess I was also looking at some of the changes like to the maintenance service.
Yes.
And because that time period changed,
Right.
didn't it?
It changed. The limitations were a little less restrictive, so we got September and all the other winter months, and longer, maintenance periods up to 60 days with varying notice. That's helpful. It might have been helpful to have, allowance per generator, but in this case, it's not that big a deal, and we're fine with the terms as is.
And I noticed in your testimony, I mean, you're pretty thorough in looking at page 4, answering the question posed at line 4, is a 10% standby reservation charge reasonable? And so you go through 5 reasons why it is, correct?
Yes.
That wasn't your testimony originally, was it?
Yeah, pretty much.
Oh, it was?
Originally, I said 10% was a max, and you really needed to demonstrate why 10% was the right number. But, we don't have any additional data to say that 10% is right or wrong. All we know is the worst case scenario is 10% may be too high, but it doesn't matter if you're going to use backup power for more than a few days, that reservation charge really doesn't come into play then after that. So the only real issue is, what will the data support even a lower percentage than 10%? And for that to be true, you really have to have more data.
You don't entertain the same notion that Mr. Berger does, that it's actually less?
It's
Or
not
I'm
really
sorry,
actually
it's actually
less on it.
more?
Yeah.
It
Yeah.
should be more than 10%?
No, because again, this gets to the dynamic of the rate itself. Remember, the reservation charge only applies basically if you're using almost no standby service in a month. Well, if you don't ever use service in a month, you don't cause any transmission costs to be incurred. You don't reserve transmission. So, but as you use the service, you pay the daily demand charge. That includes a full recovery of transmission costs as well. And so as more days of service you use, the more contribution you make to both production and transmission. And that's why the dynamics works out as a cost-based rate.
Okay. Sir, looking at your testimony on page 9, you're answering the question posed. Well, on page 9, you're answering what your prior concerns were about option 1. And you begin your testimony on line 6, saying that the large customer group proposal would have recovered 90% of the production-related, demand-related costs during the summer months. In other words, a customer with behind-the-meter solar generating would pay no contribution to production fixed costs, either during winter or the off-peak hours in summer. That was your testimony originally,
Yes.
correct?
That's right.
But since option 1's now redesigned so that the remaining production demand related costs not otherwise recovered and the standby generation charge would be recovered in either the backup and or maintenance energy charges, this lessened the risk that SPS would not otherwise recover the production demand related costs. Correct?
Correct. Yeah, in sense, it made it look more like rate 34 itself. And that's why I think the tie to cost-based rate is a lot stronger now. Because that's how costs are recovered for rate 34 customers. Except all in demand charges rather than in the energy charges.
But isn't there another possibility that rather than shift the cost to the other rate 34 customers, that potentially the cost just would have been unrecovered by SPS?
Yeah, temporarily until the next rate case. That's right.
Okay.
And we got the next rate case, so very temporary.
Okay. So the theory that SPS is going to recover its costs from somebody.
Absolutely.
Potentially.
I think that's a given. With the usual caveat of regulatory lag.
Well, when you're filing rate cases every 2 years, is there that much regulatory lag?
Yeah, there is.
Okay.
Still takes time to do a rate case.
I think, Mr. Pollock, at this point, I think I had one more. I'm going to have to think about it, but Commissioner Ellison is with us now. And I believe, Commissioner, do you have some questions for Mr. Pollock, or?
Maybe just a couple.
Please, go ahead, sir.
Hi, good afternoon, Mr. Pollock.
Sure, how are you?
Good, thank you. Sorry, I didn't hear some of your previous questions, so I may be repetitive. Do you believe that the standby service rate for solar as proposed would result in any cross subsidization from customers on the normal large generation rate?
Actually, that's what we were just discussing. And I think the answer is no, based on the way that the rate was redesigned during the settlement negotiations with the cost recovery occurring beyond just the summer on-peak hours. I think the rate will look pretty much like rate 34. And therefore that would minimize any kind of cross subsidy between them. And I think, as Mr. Higgins indicated, the rate, and I think he presented some information to us that pretty much showed that the rate probably is a little above cost for solar, but that's okay, because we don't really know what the characteristics are going to be. Just the same as the 10% is maybe a little high, but we don't know what the characteristics of the usage are going to be. But you got to start somewhere, and this is a good starting place that will ensure that there's not a cross subsidy.
Did you perform calculations based on the proposed tariff that leads you to believe that there will not be a cost subsidy?
Yes, I did. I looked at both options, and I looked at option one in more detail after this tariff was filed, and I was satisfied that with the redesign that the cost recovery under option one better mirrored the cost recovery under rate 34, which itself is a cost-based rate. And therefore I was satisfied that that was a cost-based option. Of course, option two is the option that I had addressed in my direct testimony, and that is a direct derivative from rate 34, again, the cost-based rate. So I think in both instances, because they're derivatives of the same cost-based rate, both options are by definition cost-based.
And the option two you're referring to is the other generators option?
Correct.
Do you see much interest in, I guess, large industrial customers building and operating their own cogen plants or thermal plants?
I don't know about thermal plants. Certainly there's interest in behind the meter generation. I'm not real privy to what, the thinking is. I just don't get into that. But I was telling Examiner Hurst, you read the trade press, you see all the time that companies, particularly in the oil space, are thinking about carbon capture and other kind of projects that are going to require fair amount of generation. And it might make sense to have some behind the meter generation to be able to accomplish those kinds of new technologies. So I think clearly the space is thinking about it. I think having a rate there that anticipates that potential need ahead of the time is very worthy of commission approval.
And the fact that apparently there aren't any customers in southeastern New Mexico that have large customers with their own generation. Do you think that's more reflective of the fact that the economics are very challenging, or is it more reflective of the fact that the tariff structure hasn't had a standby rate?
Yeah. Yeah, tough to say which one. I think that there is some behind the meter retail generation. It's not huge. There's a little more in Texas. Texas, of course, has a standby rate, but I'm not sure it's the lack of a standby tariff that's the issue, or it's just a matter of the economics. I think to the extent that SPS's rates can be modernized a little more to be more sensitive to time of use pricing, I think that will make the kind of projects more economical. And like I said, the industry is thinking about these things. So I think it's just a matter of trying to adapt as the technology will allow.
Okay, that's great. I think that's really all I wanted to ask at this point. Thank you.
Thank you.
Thank you, Commissioner. Mr. Pollack, did you hear Witness Higgins when I was asking about whether or not it was potentially economical for a large transmission customer of SPS to consider putting in some type of generation? And I believe that his testimony was that I would think at that point I was specifically talking about putting in like a fossil fuel type plant.
Yeah.
And his response to me was, well, it might be cost effective if you own the fuel source. Did you hear that testimony?
I listened to that. It was an interesting exchange.
Yeah. Do you think it would be more economical if you if you were one of these oil companies and owned the fuel source, had some natural gas?
I think the answer to that question would depend on the price of natural gas, right? If natural gas prices are really high, probably not, because they probably want to make more money selling the gas and burning it. But I don't know. It's
don't know necessarily that perhaps that's what they're thinking of, what type of plant they might put in. I mean, you're talking about carbon capture and those kind of things.
Yeah. I think the article I read about carbon capture was some mix of renewable and maybe some gas generation to provide some support. But again, that's just an article. It's not a real project.
Okay.
Important thing is to be able, if you're going to have equipment that's going to run 24/7, you're going to want a resource that can dispatch and meet that. So whether you do that with a combination of your own generation or SPS, I think that's just a matter to study the technical and economic feasibility.
And I guess I'm just trying to wonder about people going into endeavors other than their original business plan. Again, whether obviously businesses can and will do what they want, but from a regulatory perspective, I can tell you the aftermath is not always pretty
Right.
in that.
Well, and that's why OPL is interested in the standby issue, because obviously they don't want to be in the generation business. I mean, if if it happens, it happens, but I'm sure that's not their first preference.
Right, right. Okay. Thank you. Thank you, sir. Hearing examiner Allen, did you have questions for Mr. Pollack?
Thank you, hearing examiner Hurst. I do not have any questions for Mr. Pollack, but thank you, Mr. Pollack, for your responses today.
If I could follow up with one other question here, Examiner Hurst, on the oil and gas issue, I guess when a well is, let's say a oil and gas well in the Permian is first completed, I understand there's a period, initial period at which, it may be difficult to gather that gas and put it on a pipeline. Is it common? I guess the common practice I understand is to flare that gas initially. Is there work underway to, say, bring in a small gas generator and generate power, or is that a something that oil companies are considering?
Yeah, I don't really have any in-depth knowledge on that, Commissioner. I don't have any insights that I can really share. It would be useful.
Okay, that's fine. I was just wondering whether, perhaps our the work here on the standby rates might somehow apply to that sort of situation, but
Yeah. Certainly the fact that there's more takeaway capacity from Permian now, I think there's a lot less flaring. I think that's been in the trade press recently. So whenever you get a mismatch and you have to, gas is kind of trapped behind a pipeline constraint, then you may end up having to flare some of it. But again, I don't want to go too much above my skis here.
Sure. And yeah, I probably shouldn't either. So thank you.
Thank you.
Thank you. Remember, it's baseball season. Okay. Mr. McMillan, any redirect for Mr. Pollack?
Yes, briefly, Your Honor.
Go ahead,
Mr.
sir.
Pollack, just a few minutes ago, you were asked about the difference between your position and Mr. Berger's position on the transmission costs that go into the standby reservation charge. Could you explain the difference between your position and his?
Yeah, it's essentially the SPS takes the position that they have to report behind the meter generation that occurs at the time of the peak in order to they report that to SPP, and SPP then utilizes that information to determine how certain transmission system costs are allocated among the different load serving entities within SPP. That practice is not consistent. We believe it's contrary to the open access transmission tariff. And it's also helping to inflate the costs that SPS is paying for transmission. We don't think behind the meter retail generation is a network load that has to be reported to SPP, and therefore going to take a pretty strong position in the next rate case about that.
But regardless of which way you look at it, Mr. Berger's position or yours, either way, you think that the 10% capacity reservation charge is in this instance a cost-based rate, correct?
It's a starting point, and yes, I believe it's a reasonable place to start as a cost-based rate.
Thank you, Mr. Pollack. Nothing further, Your Honor.
Thank you, Mr. McMillan. Anyone else have any questions based on my questions or Commissioner Ellison's questions?
Hearing Examiner Hurst. I have
Mr. Rushoff.
Hi, I have just
Hi.
a couple.
Go ahead, sir.
Good afternoon, Mr. Pollack. I wanted to go back to, you were having a conversation with the hearing examiner. I don't want to butcher this, but I think the question was along the lines of whether the NMLCG customers were the only beneficiaries of this stipulation tariff. And I think your answer was along the lines of any large customer interested in behind the meter generation would benefit from the stipulated tariff. Do you recall that conversation?
Yes.
Okay. I just want to ask, is it possible that all SPS customers could benefit from this tariff in the form of lower generation investment, lower rate base?
Quite possible. I mean, it remains to be seen, but at least it provides that opportunity, right? Because if customers can invest in more cost-effective generation, at the same time help the state meet its RPS requirements, I think that's probably a win-win situation.
Thanks. And that was leading to another question. Do you think it's possible that all New Mexicans generally could benefit from this tariff in the form of more renewable generation?
I mean, if this tariff was applicable to all New Mexicans, that might be the case, but at least we can narrow it down to the SPS part of New Mexico.
I think what I was getting to was more broadly benefits in the form of reduced emissions, environmental benefits to this tariff, encouraging investment in more renewables. Do you think that could be a benefit?
It's certainly possible. I mean, to the extent that you can offset the emitting resources with the non-emitting ones and still keep the lights on, yes, that would be a benefit.
Yes,
That's of course, that's the challenge.
Sure. Thank you. That's my only question. Examiner Hurst, I think you're muted.
Okay, thank you. Any other questions for Mr. Pollock? No. All right, Mr. Pollock, good to see you again. Thank you, sir. You are excused.
Thank you for your time. Appreciate it.
Appreciate you. And I believe our next witness will be Mr. Pagacco. You have a witness for staff.
Your Honor, could we take a break?
Yes, sir, we sure can. It is, let's come back in 10 minutes. Let's just say it's 2:55. We'll come back at 3:05. And then, Mr. Pagacco, you'll have a witness.
Thank you.
Thank you.
A hearing
There we go.
examiner, there you go.
Yeah,
Hear you.
I guess I've gotten to that point in my career. I just talk to myself. Although I've heard it's only bad if you start answering yourself. I think I do that too. Oh, well. We are back from our recess. And Mr. Bagatko, I believe staff has a witness.
Yes, Madam Hearing Examiner, we have one witness in this case, and that's Ms. Georgette Ramey, who I would call to the stand, and she's already on board with our Zoom get together.
There she is. Hello, Miss Ramey.
Good afternoon, Madam Hearing Examiner and everyone.
Good afternoon. Mr. Lee, would you please swear Miss Ramey in?
Ms. Ramey, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, nothing but the truth?
Yes, I do.
Thank you, ma'am.
Thank you, sir. Mr. Bagatko?
Madam Hearing Examiner, thank you. Ms. Ramey, how are you today?
I'm well, thank you.
Outstanding. I trust and hope that you have a copy of your testimony you filed in support of the stipulation in this case on April 10th, 2023. Am I correct?
Yes,
And that's been provisionally marked as Staff Stipulation Exhibit 1. Is that correct?
yes.
Ms. Ramey, would you just take a moment and flip through that and make sure it is a complete and accurate copy of what you caused to be filed in this case back on April 10th?
It appears to be.
And you do not have any exhibits, correct?
That is correct.
And this testimony, this was filed by you or at your, this was put together or drafted by you or at your direction, correct? Oh, it looks like she's frozen.
A few of them. I got a message too saying mine was unstable, but I'm gonna keep my fingers crossed.
Okay. Well, you froze up there for a bit for me, and the question I had asked was to make sure that this testimony was written or prepared by you or at your direction, and I believe the answer to that is yes. Am I correct?
Yes, it is. You're correct.
Thank you. And if you were asked today at this public hearing the same questions as what we see posed in your testimony in support of the stipulation, would your answers to those questions be the same as what we see in that document, or would you have cause now to change or amend any of those answers?
They would remain as filed.
Thank you. And then finally, it's my understanding, Ms. Ramey, that you do not have any corrections to make to your testimony that we're looking at right now. Am I correct in that presumption?
Yes, you're correct.
Well, thank you so much for all of that, Ms. Ramey. And with that, Madam Hearing Examiner, I would tender Ms. Ramey for cross-examination.
You're muted.
Keep doing that. Would you like to offer your exhibit first, Mr. Bagatko?
Oh, yes, please. I would respectfully move the testimony of Ms. Georgette Ramey in support of the uncontested comprehensive stipulation in the evidentiary record, and it has been marked as Staff Stipulation Exhibit 1. Thank you.
Thank you. Any objection to what's been identified as Staff Exhibit 1 in support of the stipulation, Ms. Ramey's testimony as affirmed by her here today? Hearing no objection, Staff Exhibit 1 is admitted.
Thank
Mr.
you for that.
Bagatko.
Thank you. And with that, Madam Hearing Examiner, I would tender Ms. Ramey for cross-examination or examination by the hearing examiners or whomever else might be interested. Thank you.
Very well. Thank you, sir. Any cross-examination by the parties of Ms. Ramey's testimony? Don't you just love a stipulation, Ms. Ramey?
Yes,
Of course, I have a few questions.
of course.
Not too many
Okay.
here today. Oh, we'll start off with the same question that you've probably been hearing on YouTube, if you've been listening on YouTube. Were you listening on YouTube?
Yes, ma'am.
How did you get there?
To where we are today?
No, how did you get to the YouTube?
Oh, I had to go do a general search and look up PRC hearings, and then in YouTube. And I had to I had to go like any other public servant because my link would not work.
Okay, so your link didn't work from the PRC website?
Correct.
Okay, thank you. So I've been asking people, what took so long?
I don't know, but I am so glad that we did get to the point that we did get a stipulation, because it could have gone another way. So staff is pleased that an agreement was reached, even though it took a little time.
Well, Ms. Ramey, does that mean that you didn't like hearing examiner and Allen and my recommended decision in the case?
Well, Madam Hearing Examiner, I would say that, the recommended decision was the impetus for us to be here today. So staff would say, thank you.
Good answer. Very, very diplomatic, Ms. Ramey. So then I take it is seriously your position that the product that's being offered to the commission in the form of this stipulation, you believe is a better resolution than where the parties were 6 or 8 weeks ago?
Absolutely.
And in your testimony, beginning at page 9, you begin to discuss the concerns that you originally had with the proposed standby tariff, correct?
Yes.
And before we go away from page 9, I guess generally, you conclude that the agreement is fair, just, reasonable, and cost-based. What makes you think it's fair and reasonable?
Well, the parties took a lot of time and effort to discuss the specifics and the details. And so, of course, with any stipulation, there is some compromise. Didn't get what they wanted, but out of the recommendations and all the discussions that did transpire, and believe me, we had a good 5 or 6 meetings or more discussing the details and going through the various issues and the language. And we were able to get to this point with a lot of back and forth. So with the parties, stepping up and, truly discussing and at sometimes quite passionate, I would say, we came to this stipulation, which I think is a good starting point. required investments to use the rate and give them some sort of comfort to move forward with the transition to renewables.
And further on page 9, lines 17 through 18, you testify that the proposed tariff applies to customers for any type of behind the meter generation. Is that correct?
Yes.
So then you believe that do you believe that option 1, the solar option, is for solar, and option 2 would apply to any other technology?
That is my understanding.
And I know, continuing your testimony on pages 10 and 11, you indicated on page 11, the question posed at lines 8 through 10, that staff had concerns pertaining to the contract period in the original tariff, and that those have been addressed now. Is that correct?
Yes.
And was that one of the definitional changes that SPS had agreed to in the litigated case? Or was that something new?
It was a concern in the case, in the litigated case, but at that time, SPS was willing to address it, is my recollection.
Ms. Ribby, in your conclusions and recommendations on page 13, you conclude that while the standby tariff only addresses one customer class, that it provides a good start for SPS customers to invest in the necessary infrastructure for behind the meter generation to assist New Mexico in moving forward with clean energy alternatives. Correct?
Yes.
Do you have any concerns that providing this tariff for only the one customer class might have some negative ramifications to any of the other customer classes?
Well, no, staff does not have that concern, but a majority of SPS's customers are large industrial and commercial customers as compared to, they're non-residential and whereas, P&M and SPS, their customer, and EPE, excuse me, their customer bases are almost an opposite composition where they're more residential. I think, depending on the type of behind the meter generation that may be considered by their customers, it gives them some flexibility to, I believe, look at various alternatives. I'm not an engineer, but I'm sure that, due to the type of project or investment that would be needed to install behind the meter generation, it's not a quick process. It takes time. The companies would probably have to issue a request for proposals from different
Mr. Bagacco?
I'm contacting her right now.
Yep. You've frozen up and we missed your answer, Ms. Ramey. Are you still frozen? If we want to go to an audio only,
Yeah, I keep getting internet connection unstable for some reason, but you know, I live around schools. I have no explanation. Okay. I'm sorry about that. Is this better?
we can try with your video off, or we'll go to an, I've only got a couple more questions. So
Okay.
you need to go back and finish your answer up there on,
Okay. Can you hear me all right now?
yes.
Okay. What I was saying was most of these companies that will, you know, take the time to invest in behind the meter generation will project. It would, you know, probably require a year or two minimum to conduct studies, requests for proposals and things of that nature to determine whether or not they thought it was an economically feasible idea, depending on the type of generation, as well as the capacity that they would feel that they needed. So with that said, if say the other classes would be interested, I'm sure by the time that SPS comes back for another rate case, that could be something that could be included to update the tariff to expand that have participated in the negotiations and that do have some interest and that would like to proceed, that they have some idea of, you know, what would apply under the circumstances. And as some of the other parties have said, you know, this will, it's a start in that, you know, once something does get, I guess, implemented and activated, then you will have some real data to move forward with and then can adjust from there.
Well, since you're the numbers person, Ms. Ramey, when you looked at all the numbers and the different rates, I know that you know that you provided testimony that you believed that the rates and charges were reasonable, correct?
Okay, I'm sorry, ma'am, I didn't hear you. You froze up at the end.
You provided testimony that you believe that the rates and charges are reasonable?
Yes.
At the bottom of page 13, staff believes the stipulation results in fair, just, and reasonable rates. In your review to make that determination, do you believe that the commission should be concerned about any problem of cross subsidies?
No, the way the rates have been designed and with the discussions that took place, that was definitely something that the parties wanted to ensure would not happen.
Okay, Ms. Ramey, that's what I wanted to hear from you. Thank you. Hearing examiner Allen, any questions from you?
Thank you, hearing examiner Hurst. I do not have any questions for Ms. Ramey, but Ms. Ramey, thank you for your testimony today.
Thank you, ma'am.
Thank you, hearing examiner Allen. Any questions? Any redirect, Mr. Bagacco, or any questions from the other parties?
Madam Hearing Examiner, thank you for your questions. No redirect necessary.
Okay. I don't hear that anybody else has any questions. So Ms. Ramey, you are excused.
Thank you, and my apologies for the technical difficulties.
Thank you. Mr. Begecko, anything further from staff?
Nothing further from staff. Thank you, Madam Hearing Examiner.
Okay, very well. Well, that concludes the presentation of the witnesses that are available for examination today. And the only witness subject to finding out different, it's our belief that Mr. Gorman will be available for examination at 9 o'clock tomorrow. And therefore, unless anybody has anything procedural that we need to deal with, and I'm not seeing any little hands or anything like that. Thank you. We will recess until 9 o'clock tomorrow morning. Thank you.
Thank you. Good night.
Thank you.